Welcome, everyone. We'll give just a couple minutes for folks to join. I see that we have a lot of attendees popping in now. Thank you all so much for being here today for the Power Act CLE. Morning, Judge Marshall. Welcome.
Perfect.
All right. Thank you, Jake.
Yes, sir.
Good morning.
Morning. We're giving folks just a couple minutes to get joined. I think we're expecting close to 300. Potentially, it looks like we're about 140, so we'll give it just one more minute before we get started.
Absolutely. Fine to wait as long as you would like.
All right, it looks like folks have joined now. Good afternoon, everyone. My name is Jordan Bates Rogers. I'm the Executive Director of the Arkansas Access to Justice Commission and Foundation. Thank you all so much for joining us for the Power Act CLE. I'm going to turn things over to Judge Bryce Marshall to get us kicked off. Judge Marshall is the Chief Judge for the U.S. District Court for the Eastern District of Arkansas, a graduate of Harvard Law School and confirmed in 2010 to the bench. Judge Marshall, I'll let you take over now.
Thank you, Jordan. It's good to be here, and I wish I could see everyone, but I hope you can see and hear me. Thank you for participating in the CLE today. On behalf of my brothers and sisters on the Western District of Arkansas and the Eastern District of Arkansas, welcome. This is a joint program of our two courts with the essential partnership of the Arkansas Access to Justice Commission. We could not have pulled this off without Jordan and Christy Park and the work that they did with our IT folks to use the commission's platform. I'm sure everybody will, and you should, get your 1 hour of, or several hours of CLE this afternoon. Good programming that has been put together. But my thought is that you're here for another reason, primarily, and that is because you take seriously the obligation that each of us has to do work for the public good. When we became lawyers, as I know you'll remember, we raised our hand and said that we would not reject any potential client from any consideration personal to ourselves. And we're called to help the impoverished, the defenseless, the unpopular. That's part of the lawyer's duty. And our program today, this good series that everyone has pulled together will help us do that. I wish that I could hear Ms. Goff talk about the 5 W's of the Domestic Abuse Act. And I'm sure that I would learn from Ms. Sutherland's talk about the trauma-informed attorney. And likewise, our closing panel with Professor Cain and Ms. Dempsey from our United States Attorney's Office, and of course, Greg Jones from the Wright firm, and our own Judge Deere. Let me end on Judge Deere and get out of the way so that y'all can have the program. She has been the hub of the wheel who has organized the sessions and worked with Jordan and the commission to pull this off. And I thank her for leading in that. Jordan, back to you.
Thank you so much, Judge Marshall. Before I introduce our first speaker, Mary Goff, I do want to cover a few housekeeping matters for everybody attending today. Well, first, thank you so much to all the co-sponsors of the event, the federal courts for the Eastern and Western Districts of Arkansas, both law schools here, the Pulaski County Bar Association, and JLAP. We really appreciate everyone's help who's pulled this together today. If you have a question for any of the panelists or presenters today, please use the Q&A function that you'll see at the bottom of your screen, and that'll pop up so that they can see your questions and answer them. You also need to be listening for the CLE code that will be provided during each session. So the presenters will announce that during their presentation. So just keep an eye out for that, write it down. That's how you verify your attendance. You should have received a CLE form already today, but if you did not, you can access the CLE form and the materials for today's presentations at arkansasjustice.org/power. And we'll put that in the chat in case you need that. You should be able to find that now. CLE forms are due to Carol King by September 29th, and late forms will not be accepted. So please make sure that you get those forms in on time. And then one last thing, and we'll get started. Professional conduct does like us to remind folks that you can only claim credit for webinars that you actually attend the entire event. So please make sure you only claim credit for sessions that you fully attend. And Zoom does keep a record of how long you were in the session, and we are required to share that with professional programs. And so let's get started now with Mary Goff. She's going to cover the 5 W's of the Domestic Abuse Act. Mary's the supervising attorney of the Domestic Justice Work Group at Legal Aid of Arkansas. She's got a decade of public interest service. She's worked at DHS and as a public defender. She's fluent in Spanish, thanks to growing up in Costa Rica. And Mary asks that if you have questions during her session, go ahead and drop those in the Q&A while she's talking, and she'll field those as she goes through her presentation. Mary, I'll stop talking and turn it over to you now. Thank you so much.
Great. Thank you so much. And good afternoon, everybody. I hope that you are awake. We are going to go through the 5 W's of the Domestic Abuse Act. Can you see my screen? We are going to cover why, where, who, what, and when. I'm sorry, it may not be in the order you're used to, but that's the order that made sense to me. Before we do that, let's talk about the CLE code. The word of the day is enigma. So if you need that to get credit, there you go.
Mary, it looks like we're not able to see your screen.
Give me just a second. Let me.
And thank you. Someone pointed out in the chat that if for some reason we're not able to get the slides up on the screen, you can go to arkansasjustice.org/power to download them.
How about now?
Yes, we can see them now.
All right.
All right.
Now you can see the word enigma instead of just hearing it. Let's start out with why. So why does the Domestic Abuse Act even exist? What is the purpose of the act? I want to give you this screen, and you might see this a few times throughout the presentation. And the reason I'm giving this to you is so that you can see how this is actually structured, because the way I'm presenting it is sort of chaotic and doesn't make a nice line like this. So you can see that this is found at Title 9, Chapter 15, 101, and everything that follows. There are actually more than 2 subchapters, but these are the 2 that we're going to focus on today. So let's talk about why we need the Domestic Abuse Act. We live in Arkansas. I love the beauty of Arkansas. My family loves being outside. We love taking advantage of kayaking, hiking. This time of year is a perfect time of year to get out and explore Arkansas. Arkansas is great in that way, but we also have a domestic violence problem in Arkansas. And according to the National Coalition Against Domestic Violence, in the United States at large, 33% of women and 25% of men have experienced abuse. Arkansas is actually outpacing the nation. And in Arkansas, 40.8% of Arkansas women and 34.8% of men have experienced some kind of intimate partner violence. Additionally, Arkansas, and this is from 2017, and we're a few years behind, but these numbers kind of stay the same. So in 2017, Arkansas had the 3rd highest rate of women murdered by men in the country. And 56% of intimate partner homicides were committed with firearms. So I think that lays a pretty good basis for why we need the Domestic Abuse Act. You can read the entire paragraph of the purpose at 915-101. I'm not going to read that to you, but to consolidate all of that information, the two main reasons are to protect victims of abuse and to prevent further violence. Let's talk about now where some of these things unfold. Let's talk about jurisdiction and venue. That's always the first thing you need when you file a pleading. You need to know where you're supposed to do it. So again, looking at the Domestic Abuse Act, this is going to be found at 915-201. And all the petitions that are filed are filed verified. So they're accompanied by an affidavit signed by the petitioner. There's 3 places you can file. It can be the county where the petitioner resides. That's usually what we see. It could also be the county where the alleged abuse occurred, or it can be the county where the respondent can be served. These are filed in the circuit courts. However, there is an allowance for certain district courts to hear these cases. And when there is a district court hearing one of these cases, it's treated as a circuit court in the sense that any order issued or coming out of the district court is a final ruling for purposes of appeal. So the rules of appellate procedure apply as if it was coming out of the circuit court. Let's move on to who can seek relief and who is involved in the enforcement component of an order of protection. Going back to our statute again, I've highlighted several provisions that we'll be drawing from to talk about this information. So who can seek relief? I like to tell the people I'm working with, and when we're training on orders of protection, just remember 2 things. You have to have someone alleged domestic abuse, and we'll talk about what that means in a minute. And it has to be a family or household member. If you can remember those 2 components and prove those 2 things, you're off to a really, really good chance of getting an order of protection. So a petitioner is anyone who is a family or household member, and we'll look at that definition in just a moment, can file on behalf of him or herself. They can file on behalf of another family or household member who's a minor, a child. They can file on behalf of a family or household member who has been adjudicated incompetent, so an adult who is a ward, who has a guardianship, or the other person who can file who isn't a household member is anyone who volunteers at a domestic violence shelter, and they can file on behalf of minors. Now, family or household member is a term defined in the Act, and I've listed here who all that means. And basically, it's everyone you would think of as family, but it also means anyone who has resided or cohabitated together, either now or in the past. It also is folks who have a child in common, and it's anyone who has been in a dating relationship, either currently in one or in the past. I've highlighted or bolded dating relationship here because that is also a term defined in the Act. So what is a dating relationship? Well, it is a romantic and intimate social relationship, but the courts are going to look at 3 things. How long was the relationship? What type of relationship was it? And how often did the folks in the relationship interact? And there is a specific provision saying this is not just like meeting at the water cooler back when we weren't working from home all the time. Just casual engagements like that are not going to count as a dating relationship. So sometimes this actually has to be analyzed. Let's talk about now the definition of what is domestic abuse. And there are 3 basic things that can constitute domestic abuse. The main one we think of is physical harm, bodily injury, or assault. But you can also get an order of protection if you are afraid of imminent harm, bodily injury, or assault. This has to be between family or household members. And then finally, you can get an order of protection if there's been any sexual conduct between family or household members that constitutes a crime under the laws of Arkansas. So if you are looking at a case that kind of smacks of sexual misconduct, you need to look at the criminal code and see if it actually is a crime in Arkansas. Now, there is this provision that has been added to the code. This became effective at the end of July of this year, and it's called basically course of control. It includes two new definitions. You can get a temporary order of protection for a pattern or behavior that in purpose or effect unreasonably interferes with the free will and personal liberty of a person. This is all a little vague. It's not as clear as some of the other definitions. And I forgot to highlight it, but it's down at the very bottom. So I won't spend too much time talking about how this is a pet peeve of mine, but we already have definitions up at 915-103. It would have been really nice if these new provisions would have been folded into the definitions, and so that the statute flowed, and by proving domestic abuse, you could still get an order of protection. It's still unclear how this provision is going to be handled if someone alleges one of the courses of conduct that are described. So these are the various conduct that is described in this part of the statute. If you look at these, you can see that some of them are repetitive. They could already be folded in up under domestic abuse. Some of these describe physical abuse, such as attacking the other party. Threatening the other party presumably includes fear of physical abuse. So some of these are already, I think they are a little repetitive. However, the one that is pretty important that hasn't been in our statute previously and is now making an appearance is stalking the other party. Stalking is a big problem, and it has been difficult to characterize it under the current definition of domestic abuse. So I'm happy to see that this is now at least in the statute, and hopefully we will be able to use that to protect more people. Let's look at some other important people besides the petitioner involved in orders of protection. So we need to talk about judges and law enforcement. The main point I want to make about judges under the Domestic Abuse Act is that there are certain items within the act that are discretionary. And one of those items, we're going to look at more closely in a minute, what kind of relief is available under the act. But the judge has discretion on what relief to order. So there's a litany of items that are available. The judge doesn't have to order all of them. They can pick and choose based on the circumstances. One example of something that is not discretionary under the act is that the court has to hold a hearing once a petition is filed, and it has to be held within 30 days, barring a few exceptions. Now, law enforcement is mentioned multiple times throughout the act. They are so important. It is so vital that we work together to make this happen, to protect people in the state of Arkansas. And law enforcement's role is crucial and essential. I've listed here one example of how law enforcement shows up in the act and something they can do to help. This is what we think of as a civil standby. So this provision right here is for law enforcement to help a petitioner go back and gather personal belongings, perhaps that they left behind when they fled the home, or they can go back and let petitioner get back in the home and remove the respondent. This right here is the notice to law enforcement that is on the AOC's form. So a final order of protection form exists on the AOC website, and it includes this language. I drew it right from there, just copied and pasted it on here. As you can see, they reference the statute, but it allows law enforcement to arrest an individual who's violated the order of protection upon probable cause. They don't have to wait for a warrant. They could just do it right then and there. We see varying degrees of not compliance, but a range of enforcement activities on this point. Several jurisdictions require an individual to actually go down and file an affidavit to state that the order of protection has been violated. Oftentimes, the law enforcement isn't willing to arrest someone without a warrant. Additionally, it says that law enforcement cannot arrest or shall not arrest a petitioner for a violation of an order of protection issued against the respondent. I haven't necessarily seen law enforcement arresting a petitioner, but I have heard several instances of law enforcement threatening to arrest a petitioner if they continue to call to report violations of an order of protection. And the rest is standard, you know, it's entitled to full faith and credit, and it's enforceable everywhere. So two other components about enforcement that I wanted to talk about, which can be kind of confusing in the act, but there is the criminal component of enforcement, and then we have good old-fashioned contempt. So the criminal component is what makes an order of protection better than a no contact order. It's written into the statute. You have to read it together with Arkansas Code annotated 553-134, which is the criminal code that lays out the elements of a violation of an order of protection. And so if a person violates the order of protection, there's 3 elements to the criminal code. The order of protection has to be issued. They had to have received actual notice or have been served. And then they have to knowingly violate a condition of the order of protection. If they do that, if a respondent does that, then the first violation is a Class A misdemeanor, and a second violation within 5 years of an initial conviction is supposed to be a Class D felony. This again varies throughout the state, but, and this is kind of anecdotal, I'm not giving you actual statistics here, but I have seen several instances where an individual violates the order of protection and is charged with a misdemeanor, and they violate it again and they're charged with a misdemeanor again. There does not seem to be this progressive charging that is contemplated in the act. I would love to see it happen more systematically and sooner, and as a matter of course, because an individual who is violating the order of protection has no regard for the law and is dangerous for our clients and for the people who are to be protected by an order of protection. There is a case here if you want to look at this. Jordan, do you need me? Did you just popped up?
Yeah, I was just going to let you know that we have a question. Ronald Nichols is asking, what happens if the petition is not heard within 30 days?
Well, that depends, and I might answer your question better. We're going to talk about when and some of the timelines. There are instances where a continuance is appropriate. So if you don't mind, I'll get to that when we're talking about when, and if I don't answer your question, chime back in if that works. Standridge versus State is a case that's worth knowing, and it also highlights the confusion between the criminal code and then civil contempt action. In that case, the state, I don't mean to shame the state, but the case exists, it's out there. The state brought a action against an individual, and they charged them under the Civil Act. So they charged them under the Domestic Abuse Act instead of charging them under the criminal code. And so the Court of Appeals, the Supreme Court had to dismiss for lack of jurisdiction because that isn't, the state can't do that. They can't bring charges against someone under the civil code. I want to take a moment to talk about Brenda Strickland. May she rest in peace and may she rest in power. Brenda was awarded a 2-year order of protection in February of this year. And in July of this year, Charles Walker violated the order of protection. He was facing misdemeanor charges for violating that. He was released from jail and he was awaiting trial, and it was set for trial on August 5th of 2021. And on August 2nd, he found Brenda and he brutally murdered her. And her life mattered, and she deserved protection, and she did what she was supposed to do and got an order of protection. And ultimately, the piece of paper, the order of protection, was not enough. And I say again, we need to work together, all the moving parts in society. We need each other to protect people like Brenda. So we can do our part and ask for the order of protection and present her case. The judge gave her the order of protection and law enforcement had arrested him, but we need to continue to move forward and make sure we are recognizing the danger and protecting people so that this never happens again. Outside of criminal contempt, we also have just regular civil contempt, and contempt is a little bit complex, and I'm not going to go into all of that right now, but the act itself allows for contempt, and then anytime that someone disobeys the orders of the court has inherent power to punish through its contempt powers. And another day I'll do a CLE on contempt because it's fascinating and interesting, but suffice it to say, if the state declines to bring a criminal case, you can still bring a civil case for contempt. Let's move on and talk about what types of orders are available. Once again, these are the components or the segments of the statute that I'm going to be drawing from. Before we can get an order, we have to know our burden of proof, and we have to meet our burden of proof. So what is the burden of proof for bringing a case under the Domestic Abuse Act? Preponderance of the evidence. This is great news. It means we can do it. We can meet the preponderance of the evidence. I want to talk about a case, Smith versus Murphy. This case is fantastic. Go read it because it lays out examples, and I'm about to lay them out for you. It lays out examples of what constitutes domestic abuse and what does not constitute domestic abuse. So before you can get your order, you got to prove domestic abuse. These are cases listed within Smith versus Murphy where the court did find domestic abuse. For example, in Pablo versus Crowder, when a boyfriend grabbed a girlfriend, screamed obscenities in her face, burst a bottle of beer behind her at a party, and made her afraid. Another example, when a guy threatens to beat up a girlfriend, and this was 4 months before the petition was filed, that was found to be domestic abuse. A girlfriend hitting a boyfriend and sending text messages threatening to kill herself in front of him, not kill him, kill herself in front of him. That was domestic abuse. And then gunshots fired outside of a house by a spouse was also considered to be domestic abuse. Let's look at some examples of what is not domestic abuse. And I think they're kind of obvious when you see them, you're like, yeah, no, that doesn't really pass even my test of what domestic abuse is. A teenage boyfriend procuring morning after pill for a teenage girlfriend. Nope, that's not going to cut it. You're not going to get an order of protection for that. A car accident. No, sorry. Bruising that on a neighbor that was not inconsistent with fingerprints. That is just not even up to preponderance of the evidence. You will not get an order of protection for something like that. And then a husband pulling a phone out of the wall and closing the living room blinds. First of all, we don't have phones in the walls anymore, so that's kind of anachronistic. But that level of outrage isn't going to be enough to constitute domestic abuse. Well, once we've proved domestic abuse, what relief is available? And as you recall, I mentioned earlier that the judge has discretion on what kind of relief to order. So this is the section of the statute I was talking about where they can pick and choose what to do once they find domestic abuse. And some of the things are, order the respondent to leave the home, order the respondent to stay away from the place of employment. They can also make a temporary custody order. They can also order child support. They can order a little bit of spousal support if that's required by the circumstances. So there are two different types of orders that are contemplated in the Domestic Abuse Act. The first is the ex parte temporary order of protection. The second is a final order of protection. Okay, so we're going to look at each of these separately. In order to get an ex parte temporary order of protection, you have to show either immediate and present danger of domestic abuse, or that the respondent, the abuser, is about to get out of jail within 30 days. If you can show both of the one or two of those things in your petition, then you should get a temporary order of protection. And the order of protection is effective until you have your hearing. And it provides all that relief that we just talked about right here. You can have any of that ordered in an ex parte temporary order of protection. It isn't appealable, so it's not a final order. You can't take it up on appeal. And importantly, a temporary order of protection prohibits the respondent from possessing firearms during the period it's in effect. And that is found, it's stated in the Domestic Abuse Act, and it cross-references the federal statute. That provision applies in the temporary order. It applies in the final order of protection. Please note that just because you don't get a temporary order of protection, so if you can't meet one of these two things, you don't allege immediate and present danger of abuse, or the abuser isn't about to get out of jail, that doesn't mean that you don't still get a hearing. So you're required to have a hearing on your petition, even if you don't get a temporary order of protection. Compare that to a final order of protection. Now, the final order of protection is only put in place after a hearing, full hearing on the merits. And the relief is the same that I just mentioned. And the important to note that custody orders and relief related to children in custody and alimony, all of that is subject to being changed by a different court, a family law court, making rulings after a hearing on the merits in a different case, such as a custody case, a divorce case, a guardianship. So that court's ruling would actually then come in and impact the findings in the final order of protection. So even though it's called a final order of protection, there are certain provisions that aren't actually final. Again, the prohibition on possessing firearms is during the period that the order is in effect. So this means that if you have an order of protection that lasts 1 year, the prohibition on holding firearms lasts 1 year. It does not last longer than the expiration of the order of protection. Important to note that the OPs are effective. They are required by the statute to be for a fixed period of time. And the minimum is 90 days, the maximum is 10 years. That is a provision that I think there's some scope creep going on, because sometimes you will see judges say, well, we're going to have this order of protection in place until your divorce hearing. That isn't necessarily a fixed period of time, because as everyone knows, in practice, a hearing date is subject to multiple continuances. So these really need to have a fixed date, 90 days to 10 years. Also, the form for a final order of protection is, there's a sweet one, nice one, perfect one available on the AOC website. Sadly, it isn't used uniformly across the state. I don't really know the reason for that, except we always think we can do things better. And in practice, there are maybe certain things that the court thinks they need, but it would be really nice if everyone used the form available on the AOC website so we had some uniformity. And then the final order of protection is effective once it is served on the respondent. I would like to give a shout out to Benton County. They do a fantastic job of this. Once the hearing is concluded, nobody's allowed to leave until they get the order printed out, file marked, and served on the respondent. And so you leave a hearing with everything in place that you need for enforcement. There are a few other orders contemplated in the Act. A no contact order is a step down. I call it a step down from an order of protection. And one of the main reasons is that it does not have the enforcement mechanisms and the separate crime associated with it that an order of protection does. There's a prohibition on mutual orders of protection. The only time you could do that is if both parties are actually petitioners. So you have, female petitioner alleging domestic abuse against boyfriend, and male petitioner alleging domestic abuse against girlfriend, and they both prove domestic abuse. Then you could have 2 orders of protection issued. It rarely happens. If that's the scenario, oftentimes it's reduced to a no contact order. All right, I'm going to show you 2 slides that look almost exactly the same, but they have 2 different cases listed. They stand for the proposition that just because you have other remedies available, that is not a barrier to getting an order of protection. So Steele versus Lyon is a 2015 case that says that. And then Smith versus Murphy, we've already discussed that case a little bit, is another case from 2017 that says the same thing. It seems kind of patently obvious. At the same time, the way this plays out in court is that a judge may hesitate to grant an order of protection where they believe there is a divorce pending, and that might be a better avenue for the parties to resolve their differences. But that should not have a bearing on whether an order of protection issues if the party has alleged and proved by a preponderance of the evidence that domestic abuse occurred. Let's move to when, and hopefully I'll answer that question in some of these slides. We're looking at timelines and other time-related issues. Here are the segments of the act that we will be drawing from. And these are some time-related issues. So service, hearings and continuances, the date the abuse occurred, how long the order should last. We've already talked about that a little bit. And then imminent fear, which is part of the definition of domestic abuse. What does imminent mean? First, quickly, Arkansas Rule of Civil Procedure 81 says that the rules of civil procedure apply unless the act creates certain timelines. There is a case, Wills versus Lacefield, that says this is a special proceeding. The Domestic Abuse Act has its own timelines and different provisions. Those will trump the rules of civil procedure where they are listed. So one example is service. The statute says that the respondent has to be served at least 5 days before the date of a hearing. So this is one answer to the earlier question about what if you don't have a hearing within 30 days. The initial, the ex parte temporary order will have a hearing date on it. And let's say that hearing date is September 25th. If the respondent hasn't been served by September 20th, that hearing has to be continued. You have to comply with this, and every court that I've been in does a great job of complying with this, because it will be a void proceeding. So everyone will continue it. Every court I've been in will continue it until respondent is served. So that's one example of when a hearing might happen after the 30 days. This kind of is about talking about the same thing, that the hearing has to be within 30 days, but the rules of civil procedure allow for continuances for good cause. So there's nothing specific in the statute that says you can't get continuances. So the rules of civil procedure would apply here. Some examples of when we see good cause are, for example, if the respondent is facing criminal charges, a lot of times either party will ask for a continuance. It's usually granted. Another example is if private counsel hops in a case to represent respondent and they got 2 days notice and they need time to prepare for a hearing, a continuance is going to be granted in that case. Of course, we've seen multiple continuances for people being ill with COVID and not being able to come into court, things like that. That is not to be confused, though, with how many hearings are contemplated in the act. So a continuance means you didn't have a hearing at all. There was no hearing on the merits. You showed up, something wasn't right, or before you showed up, something wasn't right, and you had to get a different hearing date. But as far as actual hearings on the merits, the act contemplates 2. Really, the act contemplates 1 that is mandatory, and that is the hearing we've been talking about, the one that has to be held within 30 days of the issuance of the ex parte temporary order of protection, or within 30 days of the filing of a petition if the facts weren't there for an ex parte. And the second hearing that is contemplated, I mean, this could be a second hearing, a third, there could be more than a second one, but it's a second type of hearing. And it's not mandatory, and it's only made on a motion by the party. And I've listed in this slide for you different parts of the act where you can find these. So you have to kind of seek around for them. It's not listed in a linear fashion. But an example of when another hearing might be required is if, for example, the order of protection is about to expire, and the petitioner feels like they are still in danger and they need the order of protection extended. They can file a motion to extend the order of protection, and then you would have to do service and then have a full hearing on the merits. And that's because there's new facts. The reason I bring this up is because I've been in a court, a particular court in Arkansas, where the court is holding multiple temporary hearings, but there are no review hearings in the Domestic Abuse Act. And holding multiple temporary hearings brings up significant procedural problems, including for respondent, potentially, res judicata. I mean, if the issue has been tried and heard, we don't need to try it and hear it again. So when you look at the entire act, there should be one hearing on the merits unless there are new facts that need to be heard later. Let's talk about imminent physical harm. Imminent is in the definition of domestic abuse. You can have fear of imminent physical harm. What you hear argued in court by defense counsel, so I'm always on the petitioner side, but defense counsel will often argue, look, judge, she's not afraid today as they stand here. 6 months ago, they had an issue. They don't have any issues today. He's behaved himself. There's no trouble here. She's not afraid today. Well, that isn't what has to be proved. It's the imminent component is, were they afraid of physical harm at the time the alleged abuse occurred? The other issue that closely connects with that is that the abuse, the court can't deny a petitioner relief just because the abuse was more than 120 days ago. So there's not really a time constraint written into the act for when the abuse had to happen. And these concepts are solidified further. They're in some of it is in the act itself, but they're also in the Simmons versus Dixon case. You can read that at your leisure, nice bedtime reading. But that's where this comes from. It's useful, it's important. It does come up fairly regularly. What does imminent mean? And then finally, the duration. I talked about this a little bit earlier, but the reason this matters is because it has to be fixed. And I think I already hit home on this earlier, but minimum of 90 days. So court cannot order a final order of protection for 1 month. It's 90 days minimum. So if there's a finding of domestic abuse, even if it doesn't seem super serious to the court, the shortest period of time is 90 days. And the maximum, no matter how egregious, the maximum is 10 years. And then I've listed here some other resources that you may want to look at if you want to pursue the topic of domestic abuse further and find out a little more, not necessarily on the legal side of things, but a little more on the cycle of violence, on statistics regarding violence, intimate partner violence, things of that nature. You can look up some of these websites that I've listed here. And also, if you need assistance, or if you know of anyone that needs assistance, you can call the legal aid helpline. And we are always taking calls for orders of protection. We go regularly to court. We go in every county that we represent. We assist people in getting orders of protection in court. Do we have any questions?
Yeah, we've got a few questions for you, Mary. The first one that came in is, what law could have protected Brenda more? And Brenda was the example you talked about earlier in the presentation.
So the reason I folded it into the enforcement component is because I don't think it was a failing of the law. And I've thought about this a little while because that case troubles me deeply. But one of the things I want to see more of is the gradation in severity. So it's on the enforcement side, and a misdemeanor doesn't have the bond posting. I mean, people can bail out and get back out on the street right away. And what we typically see is an individual will get slapped with a fine and go on their way. So there's not actual jail time associated with it most of the time. If the act is followed where they get convicted of a misdemeanor, they pay their fine and they do it again, then it should be a felony, which is a little bit harder to wiggle out of. I mean, you can still get probation, you can still get a suspended imposition of sentence, you could still have these other remedies there, but it's a little more serious, and it might keep someone away and keep them away, I guess.
Someone else has asked, what if a respondent owns a gun? Do the police go in and seize the guns?
So typically, yes, there is. I don't know if if seizing is the right word, but they have to remove the firearm. So you'll see this enforced differently around the state. Some ways it's enforced is an individual can get rid of their guns and give them to their uncle or their brother for safekeeping. They just can't possess them. So it's not necessarily about ownership as much as having access to them.
And another question we got is, can the order be extended after 10 years for an additional period of time?
No, 10 years is the maximum. So if there is a new incident that is going to require another order of protection, I think it would need to be a new petition on new facts, and then you could start over and have another order of protection, but 10 years is the maximum.
And another question from someone is, what percentage of your clients at Legal Aid are female for orders of protection?
Oh, I wish I had come ready with that specific stat, because I bet we can find it. So I can only answer anecdotally, and I would say it's in the mid-90s. We do have, there are male victims, so it's not just a female problem, but overwhelmingly the majority of intimate partner violence in Arkansas and elsewhere is against women.
And then we had a comment, someone saying until 2019, an order of protection could only be charged as a felony if it was a subsequent offense and there was another crime occurring simultaneously to the violation. To change charging practices, we may need to do a better job educating prosecutors and law enforcement on the changes to the law. So if you have any thoughts in reaction to that, Mary.
Whoever that is, let's meet up. Let's talk about it. If you have ideas on how to go about educating and making progress in that regard, I'm certainly all ears and ready to help. I think education, I'm sorry, but I think education is always the best approach, and cross-training, talking to each other, making sure we're on the same page and understanding each other, because when it comes down to it, everyone does have the same goal. We want our Kansans to be happy and healthy and well.
And then I think we have time for one more question. Someone asks, how can the system better address order protections in criminal cases where the victim survivor recants, requests dismissal, or is unavailable?
So I think I understand the question to mean that sometimes the petitioner, the victim, survivor, is not cooperating with law enforcement or prosecution. And I would say that is also can be typical, and that's nothing to be angry about, because the literature shows us, if we learn more about the cycle of violence, it shows us that sometimes it takes people 8 attempts to leave an abusive relationship before you muster up the stamina and courage and resources to actually get out. So it isn't uncommon early on for that to happen. I know it's, we're all people, and we get demoralized as well. So prosecutors and law enforcement, you will hear this a lot, become demoralized because their efforts just result in the parties getting back together or the individual doing something anyway. But we have to have stamina and patience and understanding.
Well, Mary, thank you so much for a great presentation. I know I learned a lot, and I think other folks did as well. We appreciate you being here today. And for folks who are going to stick around with us, we're going to take a 5-minute break. There's going to be a poll launched for the next session. So at some point during the break, just answer that poll, please. And I want to remind you that the CLE form is available at arkansasjustice.org/power. You can also find Mary's presentation and the materials for the next presentation at arkansasjustice.org/power. And again, 5-minute break, and we will be back after that to start the next session.
Thank you.
Thanks, Mary. Hi, Lisa. Thank you so much for being with us today.
Jordan, glad to be here.
All right. So we'll start coming back from the break now. Give folks just a second to get settled back in before we start, Lisa. All right. Our next session is the trauma-informed lawyer. And I was so excited when I heard that Lisa was willing to present this session because I think all lawyers can benefit from being more trauma-informed. Even the best meaning lawyer can re-traumatize a client, and none of us want to do that. So I think this will be really beneficial for all of us. Lisa is a licensed clinical social worker. She works here in Central Arkansas. She has a master's in social work from the University of Arkansas at Little Rock, and along with a postgrad certification in marriage and family therapy. She has 2 sons, 3 dogs, and a cat, and enjoys hiking and exploring the natural state. And just a few housekeeping reminders for folks. Please make sure that you watch out for the CLE code during this presentation and use the Q&A if you would like to ask Lisa a question, and we'll hold her questions until the end, and then we'll cover those questions. And Lisa, I'm going to turn it over to you, and I'll mute myself and let you share your screen. And we've got the poll results up now, it looks like, as well.
Okay, great. Thank you so much. Thank you all for being here. Thank you to the organizers for organizing this event. Thank you to JLAP for inviting me. And thank you all for spending your first Friday of fall this afternoon here with us, learning about all these important topics today. I want to talk to you about being a trauma-informed attorney and kind of a lot of different things that come along with that. Let's see if I can get my presentation going here. Okay, Jordan, does that look right to you? Does that look like I'm
Yes.
sharing my screen correctly? Okay,
Yep.
Thank you. All right. They told me to share the code word for the CLE, so enigma on that if you didn't get that yet. But jumping right in here, just kind of giving some background and foundation. What is trauma? So trauma is not really an event. Often people think of it as an event. It's not an event. It's an experience of an event. It's an emotional response to an event like an accident, a rape, a natural disaster. And it's a unique individual experience. What may have been traumatic to me as a child or in life may not have been traumatic to you. So it's not it's not something that we can sort of globally define easily. It's very individual. It's an individual experience of an event or an enduring conditions in which the individual's ability to integrate his or her emotional experience is overwhelmed. And that person experiences, either objectively or subjectively in their own belief, a threat to his or her life, some sort of bodily integrity, or that of someone that they love, a caregiver, a caretaker, a family member. So it's very unique and individualized. We also look at trauma in the context often of ACEs. ACEs are adverse childhood experiences. There were 10 questions, original 10 questions asked of people that worked for Kaiser Permanente Hospital in California in the 80s. And the researchers were shocked at the level of adverse experiences in the adult population that they surveyed at that time. So those questions are around these areas: abuse, neglect, and growing up in households where there's some kind of usually dysfunction or something, some sort of adversity. So ACEs in Arkansas are very high. In 2016 and 2017, the Annie E. Casey Foundation that looks at kids count data for states all across the United States rated Arkansas as one of the top 6 worst states for children to live. And I think that was correct in their accounting, because if you look at some of the things that children in Arkansas, the adversities that they are up against, it's often pretty steep hills for many of them to climb. As we see there, the national average is 8.2% of children whose parent has served time in jail. In Arkansas, that's 16%. In Arkansas, that comes out to 109,000 children have had a parent who has spent some time in jail in our state. And as you see, in Arkansas, we're very high on the economic hardship adversities for our children. We have many children in our state that grow up in poverty. And depending on what part of the state you live in, it's very different. We have children in Benton County that live very differently than the children in Phillips County. And so we know that it's not concise across the whole state. It's different at different places. And as you see there, almost 10% of Arkansas children have witnessed domestic violence in the home. And this is 2016. We know with the pandemic that that's probably much higher now, much higher. In the family disorder that led to separation or divorce, that's at least 1/3 of Arkansas children that have experienced that. And so the ACEs work like in a pyramid where there's childhood experiences, the disrupted neurodevelopment, social, cognitive, and emotional impairment, adoption of high-risk behavior, smoking, drinking, overeating, sedentary lifestyle, and then disease, disability, and social problems. For a very long time, I thought and understood this pyramid to be where the adoption of the health and high-risk behaviors were the things that led to the disease, disability, and social problems like interactions with the legal system. It's only been in the last few years that I've gained education and understanding that it actually is in the disrupted neurodevelopment piece. After and during those adverse childhood experiences, when kids are experiencing trauma, stress, or even chronic stress, their brains and their bodies are inundated with a lot of hormones and stress hormones, cortisol. Bathing in those toxic hormones for a long time actually causes other health disruptions. Those are some of the other factors that contribute to health problems like diabetes and heart disease in the long term. It's not just the adoption of those high-risk behaviors as they get older. It's actually from an early age being exposed to those chronic toxic hormones and chemicals that cause metabolic syndrome and other diseases. And so we also know that there's multi-layers of ACEs, right? Kids aren't born in vacuums. They don't grow up in vacuums. They grow up in families. They grow up in neighborhoods. They grow up in communities and societies and towns and cities and states and all those things that affect us. And so we know that there's multi-layers here. It's not just the individual experience, but it's also the collective experience. We know even in Pulaski County, there's some neighborhoods that have a higher propensity of violence than other neighborhoods. Those children are going to be exposed to more adversity than children from neighborhoods that have lower rates of violence or lower rates of domestic violence too. And so we know that those things are all interlocked and interwoven. And as you see, a ripple effect of ACEs across our criminal justice system, right? It's not just the child that's affected. It really ripples out into so many systems and so many areas that are impacted when we think about children in adversity and how those children who've experienced adversity grow up into adults that have experienced adversity. Saw that in a documentary and it really stuck with me. At-risk kids grow up to be at-risk adults, right? There's often things that don't change in their support system or in their coping skills ability as they grow up. A lot of times those things don't get better. They get worse within the system. And what we know too is there's often intergenerational and even historical trauma. There's parts of mental health research called epigenetics that really studies how historical trauma may be activated or impacted in the person's life today. They look at it from a nature and a nurture perspective, that there is a DNA aspect to this, a hereditary aspect to intergenerational trauma that they've studied through Jewish people, the grandchildren of people who went through concentration camps. They've studied those children and noticed that they have higher rates of anxiety and higher rates of other PTSD-like symptoms. And some of them obviously are from growing up in households where those things were experienced and where that generational trauma was shared with family members, but they also believe that there's a DNA or a genetic component to that. So epigenetics is that study of that. But intergenerational trauma refers to that transmission of trauma and its effects from one generation to the next. I know in the legal system, you all see this. We see this in the mental health system where it's really generational. Had been working with a teenager who experienced rape, and the mother will tell me her story of being raped, and the grandmother will tell me her story of being sexually abused, and it's really generational. It's not just usually that person in front of us. Historical trauma refers to that cumulative or emotional and psychological wounding across generations due to massive group trauma. This is trauma at a collective level. We are all kind of experiencing that with the pandemic right now. We're all in a collective level of trauma on some level, and we've seen that in other places, whether it's been through slavery, through concentration camps, through places like Rwanda and what happened there. We see often that group level trauma historically. And so ACEs don't just have an impact on the person socially, and personally. It's not just that they go on and they have problems with their mental health, or they have problems with legal system or externalizing behaviors. They actually have a lot of health problems. It's physical health problems. Arkansas has a very high rate of ACEs. We are number one for our number one cause of death in Arkansas is heart disease, cardiovascular disease. Number 10 cause of death in Arkansas is suicide. Some of these can be traced back to early adverse childhood events. So it's very interesting the level of health, physical health problems, and the level of physical and medical issues that people who face adversity have, not just the mental health problems. And so this is talking about millions and millions and billions of dollars in health costs every year traced back to childhood adversity. So like I said, severe obesity, diabetes, depression, STIs, COPD, so many different health problems. And it comes down to a large cost for our economy, but also just cost in mental health and pain for the people experiencing those. As we know, in the United States, we have a high levels of intimate partner and family violence. This was back in 2007, but at least 25% of the United States women in the United States can experience domestic violence. I know when I was working with school-based children and that children who worked in who were sent to alternative learning environments, domestic violence was so prevalent. It was just incredible the amount of domestic violence in the home, and then carried over into behavior and anger problems for the children. And it was just such a widespread problem. In the United States, women are murdered by their partner. 3 women a day are murdered every day by their intimate partners. It's a very serious problem. With ACEs among our juvenile offenders, it's practically a given that if you have a juvenile offender in front of you, that they didn't get there by themselves, that there was a collective issue within that family, within that community, that assisted that juvenile in getting to that place where their behavior was so severe that the legal system had to intervene. At least 90% of young people in our juvenile justice system have had at least one extreme stressor, and usually far more by the time they've gotten to that point. So in Arkansas, just like our ACEs with our children, it's not a very welcoming place for women either. Arkansas has the 3rd highest rate in the United States of women who are murdered by men. 453 victims in Arkansas were served by domestic violence shelters and programs in one day in 2021. I can imagine that those were much needed this year as well. And in last year, as the pandemic worsened, I know some of the services were cut or discontinued because of the pandemic, not all of them, of course, but we know that these problems have worsened and not improved in the pandemic. An estimated 18% of women will experience stalking in their life. And I think this was really telling. As of December 31st, 2015, the latest data I could find, Arkansas has submitted 2,460 misdemeanor domestic violence records and no permanent protective orders to the NICS index. And if you look state by state, if you're looking online for data about Arkansas, the data resources are extremely poor with domestic violence. If you look for other states, you can see some up-to-date data and what they are doing. It's really difficult to find that for Arkansas. So when we're also talking about ACEs, when we're talking about trauma, we have to talk about PTSD. PTSD is a severe form of trauma experience, right? Most people who've experienced trauma, or even most people who've had ACEs, it does not grow into full-blown PTSD. That's only 5% of men and 10 to 12% of women, and about double that in our veteran population who experience PTSD. But that's still quite a lot of people. That's still over 300,000 people. So we know that that's 300,000 veterans, but over 7.7 million people total. Why? That's still a lot of people out there who are experiencing PTSD. What we know about PTSD, if you have symptoms of PTSD, and we'll talk about what those are, and they don't improve within 3 months, you need help. You won't be able to get better on your own. You need professional help. So what trauma actually looks like in someone's day-to-day life. They may not tell you they have PTSD. They may not know they have PTSD. They may not even identify that they've experienced trauma in my experience. But what it looks like is people with addiction, attempts at self-medicating, their attempts to avoid feeling what they don't want to feel through excessive use of drugs, shopping, sex, alcohol, gambling, food, pornography, video games, work, etc. They find some way to stay busy or to stay numb or to stay out of it so they don't feel or think about the things that are traumatic for them. These people often sit with their back to their wall. Their heads are on swivel, always on guard, very hyper aroused, highly anxious, nightmares, flashbacks, dissociation, often mood issues. These folks can be suicidal at times, very depressed, often negative outlooks, negative beliefs about themselves, about the world, about other people. The avoidance is high. Avoidance is what keeps the PTSD alive. So they avoid people, they avoid places, they avoid triggers, they avoid things that remind them of the traumas. It can be smells, it can be all kinds of things. But the avoidance, which seems natural, avoid the things that stress you out. The avoidance actually keeps the PTSD alive. These folks often have lots of anger. They often don't even know what they're angry about. It's misdirected anger sometimes, trust issues, self-harming behaviors like cutting. Often it comes along with disordered eating as well. There's a high trauma component to people with eating disorders or people with disordered eating. These people often have a negative, pessimistic view of the world, of themselves or others. You often get the client that everybody's an idiot but them. And that's often a trauma response, a way to sort of keep themselves safe in a backward kind of way. These trauma can also look like somatic or medicalizing issues. This comes out a lot in women where it's hurt. My body's hurting. I'm really tired. My back hurts. My leg hurts. My stomach hurts. I'm sick a lot. I just feel bad. Sometimes that's what we call somatic issues, but a lot of times that's how trauma appears in the body or depression appears in the body. It doesn't mean the person isn't actually hurting. They are hurting. It just feels it's a pain and it's physically in their body, but it's usually manifesting from something psychological, but they do truly feel the pain in their body. And so trying not to minimize that, but they do physically feel bad. People with trauma often have a tendency to isolate. They're fearful of others. They've made up stories in their head about how people are dangerous or how the world is dangerous. So they often want to be alone or be away from people, or they've told themselves that others aren't safe around them. I can't control my anger, so I need to isolate so I don't hurt people. They're often very anxious, on edge, irritable, closed off, very easily aggravated. And you see that need to always carry a weapon, always feel like they have to have something to defend themselves. When you talk to these people, if you can get them to open up, they often are shouldering a great deal of shame and guilt. It's stuff that they've placed upon themselves, but their belief that they've done things that can't be forgiven or that they've done things that are against their values. So there's often a great deal of shame that they're holding on to. And then what trauma also can look like is a great deal of legal issues, drug charges, DUIs, assault and batteries, weapons charges, domestic violence charges, child abuse. It often comes out in these externalizing behaviors. They don't know how to cope. Their regular coping skills are overwhelmed, and so they're acting out in some way. And when we're talking about helping professionals, attorneys, judges, social workers, therapists, we are often very at risk for experiencing secondary or vicarious trauma. This is the natural consequent behaviors and emotions resulting from knowing about a traumatizing event experienced by somebody else. The stress of wanting to help or wanting to do something for that suffering person, but obviously not being able to keep them from the suffering event or to fix it. And so vicarious trauma, it's an occupational challenge for people like us who work and volunteer in the fields of victim services, law enforcement, EMS, fire service, and all those other allied jobs. Due to our continuous exposure to victims of trauma and violence, we deal with a great deal of people that have had very, very bad days. So this work-related traumatic exposure can occur from such experiences: listening to them recount the victimization, looking at videos, reviewing case files, hearing or responding to the aftermath of violence, and all these other traumatic events that we are exposed to day after day after day. Also responding to mass violence incidents that have resulted in numerous injuries and death. You see a lot of vicarious trauma from first responders in that way. I treat a lot of first responders with that who not only have PTSD from their exposure to trauma, but also have secondary PTSD to other exposures in the job. So there's some things and some people that are more at risk for experiencing this vicarious or the secondary trauma. So all of us are at risk of being negatively impacted by all these effects, but there's some factors that make some people a little bit more vulnerable to this. If you yourself have had prior traumatic experiences, or even have PTSD or have some trauma in your own history, you are more at risk for having that activated as you listen to client stories. If you're somebody that has a lot of social isolation, that you don't have a lot of coworkers you connect with, or even friends outside of work, this can put you at risk for having that vicarious trauma. If you're a person that has a tendency to avoid your own feelings, if you have a tendency to withdraw or assign blame to others in stressful situations, this could be a risk factor for you. Also, as well as difficulty expressing feelings. If you have problems telling people you're overwhelmed, or have problems telling people this is difficult for you, have problems asking for help, then this could put you at more risk for experiencing secondary trauma. We know that people who aren't prepared for their position, who aren't trained well, or who don't have support or adequate supervision in their jobs are often more vulnerable to experiencing this secondary trauma. People who are kind of unprepared for the position that they're in are often at risk. If you're a newer employee and you're less experienced, you are at more risk, right? We sort of sometimes not so good, but sometimes good. We often develop a callus from hearing so many traumatic stories. It doesn't mean we're cold-hearted to those stories. It means that we've heard them, and the exposure to those stories is less shocking over time when we hear similar stories. It doesn't mean we care less. It just means the shock, right? The exposure, we've been exposed to those stories. And so being less experienced at hearing traumatic stories puts you at risk. And a constant, intense exposure, obviously, to trauma work without any variation. So I'm thrilled when I get to come and do presentations like this. I'm not sitting in an individual session right now listening to a traumatic experience. I'm getting to do something different by talking about trauma and becoming trauma informed. So trying to vary up your job. If you don't have varied tasks and you're only doing criminal defense and you're only doing rape cases, you're only doing domestic violence cases, it's going to wear on you. You need to vary some things up. And then if you don't have an effective and supportive process for discussing trauma content at work, what do you do with all of the stuff that you have? What do you do with all the stories? What do you do with all of these events, all of these traumas that other people have experienced that now you know about? Before you didn't have the knowledge, you didn't carry it. But now that you know this, you can't unknow it. So now what do you do? Luckily, in mental health, we kind of all process things together, right? I'm lucky that I have two clinical coworkers that I can talk to difficult cases with, or we can bounce things off of with, and that's how we sort of are grown up in therapy and mental health, is doing that. And I'm not so sure attorneys often get a chance to do that in the same way, that they're able to process some of the traumatic content of the work that they do with others, or even with understanding people that would know what that's like. And non-judgmental, right? There's times when we would say things that if they were heard outside the office would sound very different to people than they would to a person doing that kind of work. So having that non-judgmental space is important. So right along with it, we talk about compassion fatigue. These three terms are kind of synonymous. They're each a little bit different, but vicarious trauma, secondary trauma, compassion fatigue. Compassion fatigue refers to that deep emotional and physical wearing down that takes place when helping professionals are unable to refuel and renew. So those of you that answered this poll at the beginning, I saw the majority of you got this right. Between 40 and 85% of helping professionals develop vicarious trauma, compassion fatigue, and/or high rates of traumatic symptoms. That's very, very high, right? I'd say it's probably over 40%. So the majority of people in helping professions develop vicarious trauma. It's pretty hard to insulate yourself from it. You're going to hear these traumatic stories. You're in this job, in this profession because you care. And so it's so easy to become fatigued, to be worn out, to be tired, and to feel ineffective from what you're going through. And so part of the thing is we just have to understand. It's like we have to accept that there's a cost to this caring. There's a cost to this profession. There's a cost to being a helping professional. We're not working on Wall Street, right? We're in helping professions here. We are here because we care about humans and people. And so there is a cost to that. Professionals who listen to client stories of pain and suffering may feel similar fear, pain, and suffering because we care. Sometimes we feel as if we're losing our own sense of self to the clients we serve. I know at different times over the years, I've felt that, where I've done more for the clients I serve than I've done for myself. And that's not a great feeling to have. It's not a fair feeling to have for yourself. And so I think there's times when we do, I can only speak for me, times when I have gotten caught up into that and paid a lot for the cost of caring and worn myself down. And so now I've become more aware of the cost of this caring, right? And how much I'm willing to pay in some respects for that cost of that. Is it worth missing family time? Is it worth missing weekends to do these things or to go overboard? You know, having to have that sense of balance to the cost. And so symptoms of compassion fatigue that we see and we notice: when you feel overwhelmed, physically and emotionally exhausted, when you're having that skills breakdown, right, where you just can't, it doesn't feel like you're going to be able to keep going at this rate. Having those client and work demands regularly encroach on your personal time, where you're staying at work till 7 or 8, you're doing stuff on Saturday and Sunday with those times when it should be about your personal time. When you have disturbing images or thoughts from cases or clients intrude into your own thoughts and dreams, when you have those intrusive thoughts about work, thoughts that you can't get out of your head, you may be having some compassion fatigue. This is one we see mostly in mental health, is when people become really pessimistic about their job, when they become super cynical, irritable, and prone to anger about little things. And they just become really negative forces. We kind of start to realize, you may not, the person themselves may not realize it, but the rest of us kind of go, you're getting burned out. Okay, we see. And so that comes up too in those negative views. Negative views of clients is what we see it in mental health. Sometimes some co-workers in the profession too, but you often have a negative view of clients. Oh, him again. Oh, another one of these. Oh, these people, right? Instead of having that compassion and feeling like that you're seeing people for the first time or the first experience with this event or the situation, it feels like, not again. Viewing the world as inherently dangerous and becoming increasingly vigilant about your safety, right? If you're doing a lot of cases about violence and you start becoming super hyper vigilant yourself, or you start noticing things that you didn't used to notice, or you start becoming really super extra careful, that might be a time to really rethink, right? I'm not saying don't be careful, but if you start to notice that this has become heightened for you, it's something to think about. Also, if you become emotionally detached and numb in your professional or even your personal life, experiencing increased problems as well as in personal relationships. But if you just notice yourself not caring, like, right, I'm here, I've showed up, I've done that, like, give me a break, right? Or you just sort of become detached and you're just checked out. That could be a sign that you are just worn down. When we withdraw socially, become emotionally disconnected from others, when we start questioning our own professional competence and effectiveness. We see this too with therapists of, I'm not really helping. I'm not really doing anything for these people. I don't think I'm making a difference. When you start questioning that or not believing that what you're doing is effective, that could be a sign of compassion fatigue. And then if you start developing secret habits where you're self-medicating or having some compulsive or addictive behaviors, drinking a lot, especially if you're drinking or using drugs at work, if you're overworking, right? If you're working 60 plus hours a week, you've got to ask yourself, how is that balancing your other needs and your other aspects of your life? If you're doing secretive things about pornography and sex, if you're visiting sex workers on secret, you're using pornography at work, if you're doing these other things to numb and check out and seek pleasure, whether it's through food, gambling, or any other way, shopping, might be time to really look at that, right? What is that escape about? No judgment, but just something to look at and to put under a magnifier and just question about where that's coming from and what the purpose of that is in your life. And also, if you notice yourself becoming less productive, less effective at your job, it may be something that you want to take a look at. If you notice yourself coming in late, right, and you're always wanting to leave early, are you just burned out at work? Are you suffering from this compassion fatigue? It's not that you're a lazy employee, but have you just gotten a bit burned out? And then the one there that we noticed too is sleep disturbances, fatigue, and the loss of appetite. It could be any number of these, a combination of those, a few, a couple, any of those things. And we know attorneys have a high rate of compassion fatigue. Obviously, there's a lot of people that come into this business and come into this profession because they really want to make a difference, because they have big, giant caring hearts and they want to help people. And then they get involved in the system where it makes that very difficult. They often can feel burned out and ineffective. So approximately 61% and 46% reported experiencing concerns with anxiety and depression out of 11,500 participants. That's quite a bit, right? They also experienced social anxiety, ADHD, panic disorder, and some with bipolar disorder. And more than 11% of those 11,500 reported suicidal thoughts during their career. That's quite high. So it's something to consider that people with caring hearts are drawn to this profession, and the profession doesn't always respect that piece. And so it can often lead to that compassion fatigue. Of all the respondents, 23% reported mild or high levels of stress. I would think that's pretty low. I would think it might even be higher than that, honestly. And so when we're talking about trauma-informed care, what does this mean? It means it's a trauma-informed organization or system that realizes the widespread impact of trauma, like we talked about there with the ACEs with kids and the ACEs with juvenile offenders and the ACEs with people in the legal system, period. This is a high rate of adversity. And so there's a widespread impact of trauma in our world. Trauma-informed care recognizes the signs and symptoms of trauma in clients and families, even in your staff and other people involved in the system. Trauma-informed care responds by integrating the knowledge about trauma into policies, procedures, and practices. And most importantly, as Jordan mentioned earlier, we seek to actively resist re-traumatizing people. So many times the people who are coming to see you or coming to see me have already experienced a lot of difficulties in life. And so the major goal of trauma-informed means is we're trying to actively resist re-traumatizing these folks. In mental health, what that looked like about 20 years ago, a little bit before, but there was a huge shift. In mental health, it was always a medical diagnosis, right? Like, what's wrong with you? What's the problem? And so what happened when we became more trauma-informed in mental health, it changed the question, the fundamental question from what's wrong with you to what happened to you. It's a very different question when you think about it, from what's wrong with you, right? Or what did you do? What happened to you? What was your experience? What happened? that got you here. So when we think about trauma-informed care and trauma-informed organizations, this is a program, a system that realizes the widespread impact of trauma, recognizes those symptoms, and avoids the re-traumatization. Same thing with trauma-informed legal care, is to avoid re-traumatization and re-victimization, validate feelings and experiences of clients. Let me just quickly say, I think people often say, I think validate means agree with. Validate does not mean agree. Validate just means I understand where you came from. Doesn't mean I agree or I even see it that way. I just understand where you came from or how you got to that place. So validating feelings and experiences. And by doing that, you improve the legal advocacy by recognizing the role that trauma plays, even in the relationship that you're going to have with your client, that trauma is playing a role there. Trauma-informed legal practices aims to reduce the re-traumatization, recognize the role that plays in the lawyer-client relationship, and it integrates those practices by providing attorneys and lawyers the opportunity to increase connections to their clients and improve advocacy for them within the system. So benefits of that is you create a proactive approach to safety. You're proactively thinking about how to make your client feel safe in the environment that they're in, whether that's your office building, the correctional facility, maybe meeting with them, but you're proactively thinking ahead about that approach to helping them feel safe, right? Safety, when I'm talking about safety, I don't just mean physically safety, I mean calming that nervous system down so they can feel at ease and be open to you. If they're very hyped up, very anxious, they're not going to be able to be very communicative with you. So if we can help them feel safe, providing a safe physical environment, but safety within themselves, helping them calm their nervous system, it's going to help them be a better communicator with you. It helps improve the understanding and advocacy for your clients, reduces that possibility again of re-traumatization, improving a social environment in a way that improves all the relationships with your clients. And also it creates an environment that care for and support your staff. So when we're talking about being a trauma-informed attorney, that also means that's trickling down to the people that work for you and with you. That's everyone, not just the clients that you serve, but that's your coworkers, your employees, your staff. This will help increase the quality of your services and in the long run, hopefully reducing unnecessary interventions and reducing costs down the line. Reduces the number and types of negative encounters and events, hopefully down the road, reducing seclusion, restraints that your clients may need or isolations, and creates resiliency and strengths-based focus, right? Not what's wrong with you, what's happened to you, and how do we build on those strengths and resiliencies that you've already shown to get to this point. And then when you have that mindset or that sort of culture in your workspace, it increases the success and job satisfaction among your staff. If you have a worker that knows that they can call in that they're having a bad mental health day, or that one of their family members is struggling with mental health and they need to be there for that person that day, if they know that they can call in and share that with you and you're not going to be judgmental or you won't be shameful about that experience, you're going to have a much happier employee base and a much more satisfied job employee base that will work hard. When people feel respected at their job, they work hard for their employers. So having that respect for your staff, that they know that they just might mentally not be okay for that day. And instead of come to work and be unproductive, can they take that day off, get themselves together, and come back to work the next day and be productive? So trauma-informed lawyering includes understanding and accepting that people are the sum total of their lived experiences. Like that tree that I showed you back there, it's called the path of aces or two aces. That people are a product of the soil that they're grown into, whether that's the soil in their family, the soil in their community, the soil in their DNA, that people aren't usually on their own. They often have other environmental factors that happened or that were there. Trauma-informed lawyering includes being transparent with your clients, letting them know the process that you have and the way that you can share with them what that process is. People don't like to have things that come out of the blue or unexpected. So if you can share what's happening with them, it helps a lot. This includes a non-judgmental attitude. Boy, we're a very judgmental society, so it's really tough sometimes, especially if you've seen the same person in front of you over and over, not to feel judgmental about that situation or that person, but trying to have that non-judgmental attitude. Had a client that had come to our SUD program, our substance use program, for cocaine addiction 27 times, which is a lot, right? Most people, if you're not in a VA system, would not be able to afford it 27 times in rehab. It's quite a lot. It took him 27 times to get clean, and he was so thankful. He said, "Thank you for not giving up on me. Thank you for sticking with me. Thank you for giving me another chance, you know, when I would come and I'd leave after 3 days and go get high." And so I think, right, having that non-judgmental attitude and understanding that no matter what, people can change, people can get better. We've seen it, I've seen it, hopefully you all have seen it, that sometimes even the people that you would have written off can actually change and get better. So having that non-judgmental attitude goes a very long way to build the mutual trust and the mutual respect that you're going to need and want from your clients to be the best advocate for them. Trauma-informed lawyering includes being honest with your clients for what you can and can't do. Don't overpromise. Don't tell them or give them expectations that you cannot meet. Be honest with them. Be clear with them. Be direct. Most of the time, people, in my experience, appreciate you being honest about what you can and cannot do for them, but don't give them promises that you can't keep. And that goes along with being consistent. If you say you're going to be somewhere, be there. If you say you're going to call. It's very easy to lose trust when you're not consistent with these type of clients. Boundaries are very, very important anyway in attorney-client, just like with therapists and clients, but this goes even more. If you know your client has had an experience of trauma, and we're assuming that most people in the legal system have had some experiences with trauma and adversity, very, 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 very good boundaries are important. Often these people have learned very maladaptive coping skills or maladaptive ways to get their needs met that aren't healthy, and they will try to use them on us. And we have to be the healthy people and set the boundaries and say, no, we don't do it like that. No, this is how we do it. And at the end of the day, they will love and respect that. They will appreciate that. That's what they actually want. But unconsciously or sometimes consciously, they try these old or unhealthy maladaptive ways. So we have to be the healthy ones and keep those boundaries clear and hold those boundaries firm with these type of clients. We have to be very clear with our boundaries. When you're talking to clients with a history of trauma or people that you suspect that may have a history of trauma, acknowledging the discomfort and difficulty, speak to the obvious. Hey, I know this is really hard. Hey, I can imagine this might be difficult for you to talk about with me today. I can see that you're upset right now. I can see you're crying. Speak to the obvious, right? Speak to the observations that you make. It may seem a little weird, but people really honestly appreciate that you're not ignoring the obvious and the discomfort and the difficulty that they're having. So acknowledge that. Offer them options if they can have options about a meeting place or a time, seating. Would you prefer the door open or closed? If they can feel like they have a little bit of control or have a little bit of a voice, oftentimes they can be more cooperative and more compliant with what you're asking of them if they feel like you're willing to give them some power in the situation. It can be just small things, like I said, open door, close, meeting morning or afternoon. And then trauma-informed attorneys, they include their staff in trainings. We want our staff, from the people that answer the door, from the people that have any kind of contact with our clients, to understand that we have populations that we deal with that have experienced a lot of difficulties in life and a lot of adversity. And we want to talk to them about being non-judgmental, about having mutual respect for our clients, and all those things that we're talking about here today. We want to make sure that our full office staff knows those things. And so how do we do that? Same things we were just talking about there. Preview with them what to expect if you can. If you're going to ask for details about an experience, a domestic violence experience, a rape experience, a sexual assault, let them know you're going to need some details about that. Let them know what's going to come as much as possible. If you can, allow them to lead the conversation, asking general questions for understanding, not questions just because you're curious about it, but make sure that they really have a reason, right? That you have a reason for knowing these things, and trying to be gentle and leading those questions, but allowing them to take control of the conversation if possible. I know that's not always possible, but being able to check in with your clients. Hey, are you okay? Is this okay if we keep going? Do you need a break? Asking for permission allows them to feel in control. So many times trauma involves not having control or not having permission when something bad has happened to you. So even little things, can I shut the door? Is this okay? Gives them the sense that they have some control in this space and that their input does matter. And if you have something that you need to change or something that needs to be different about the way things are doing, if you can ask for input, that'd be great. How does it feel if we do it like this? What would you think if we met on this day in here instead of here? Asking for input. If you can, record or take notes and to avoid asking the same questions over and over. For children, please, 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 1,000 times, please, 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 please work with one of the children's advocacy centers across the state to do forensic interviews. Children should not be re-interviewed over and over about traumatic events. You should do one of the forensic interviewers with a trained specialist at the advocacy centers, please. And especially help clients understand the court process and what to expect. Even if people have been in court over and over, I can promise you they still have questions. I cannot tell you how many times people will say, well, I didn't know, he didn't tell me, and they didn't say this, and even though they've been in court many times, don't assume that they know what's going on. If you can, please help educate them about the process, about what to expect. I'm going to file this motion and the judge is going to have to rule this. And we're probably going to wait about 2 weeks and then I'll hear back. The next step is they're going to set a trial date. So giving them the information to know what's going to happen. And it can even drill down to certain things about even just the layout of your office or office building. Offer open seating when possible. If you have the ability to offer a security guard at your office, that's wonderful. I know many women who've said that they drove by the office and there were a group of men standing outside. So they didn't stop, they didn't go. So even things like that, right? We often don't think about that, but offering a safe space to just enter the building can be a big deal for some people. So how you remain trauma informed. Remember that question of what happened to you versus what did you do or what's wrong with you, but what happened to you? What was your experience? Continue taking trauma informed continuing education hours like these. Show up for these classes and these CLE events when they happen. And then 3 books that I really love and recommend are The Body Keeps the Score, Waking the Tiger, and The Boy Who Was Raised as a Dog. So continuing to read books and articles that are pertaining to trauma, continuing to look for information about brain health and brain development. Part of that is to becoming culturally competent, understanding who the clients are that are in front of you. Our Latinx and Hispanic clients have a different cultural component than our clients who are Vietnamese. So understanding that cultural context that our clients are coming from is very helpful. And then speaking of cultures, develop your culture at your workplace that supports people taking time off for their mental health. Support that. You do it as well. You become the role model for that with your office mates, with your employees, with your people by understanding the importance of mental health. So if you have a client that's experiencing a history of trauma or they have current concerning behaviors to you, refer them to a mental health professional. Right? You're an attorney. You don't want to get out of your league here with people if they obviously are experiencing some difficulties or you've noticed some things with their thoughts or their moods that seem off. Refer them to a mental health professional. If they don't have insurance, we have in Arkansas, we're lucky to have community mental health centers in each county or that cover each county. Most of them even have mobile assessors that will visit the jails. If you can, have a list of mental health professionals or clinics that you can refer to easily. John Brown University has telehealth options. They see people for free or for $15. All the community mental health centers, there's places like Centers for Youth and Families and others that will see people free or reduced rates, but try to keep a list of those handy that you know you can refer to often. If it's an emergency situation, look into a crisis stabilization unit or the emergency department if you need something right away and your client is willing to go. If you have some questions, obviously you all are legal experts, but when I was working for forensic populations, I didn't see this that often that I would have expected to, that people didn't always ask for an Act 311. And I know working with my veteran population, I very, very rarely see that, even when PTSD has been a problem and it's obviously an exacerbating symptom or even a component of the criminal behavior, that I rarely ever see people asking for a mental evaluation. So don't be afraid to ask if you think that those mental health issues could have impacted your client's mental capacity. Obviously, you all the legal experts and would know more about that piece of it. But some bit of advice: never leave a suicidal or a homicidal person alone. Consider calling one of the psychiatric hospitals, request admission, or ask if they have a mobile assessor, somebody who could come and assess for admission. The things they're going to ask you is, the person have insurance? Are they currently homicidal or suicidal? Those kind of questions, but never leave a homicidal or suicidal person alone. If you notice yourself, because this is going to happen to us, we're humans, we've experienced trauma as humans, not in addition to the vicarious trauma and adversity that we hear about and experience from our clients. So if we notice ourselves, if you notice yourself being triggered by something a client says or does, or something with a particular person or case brings up flashbacks, memories, intrusive thoughts, problematic feelings, do not ignore them, which is what we usually do, right? Don't ignore these. This is your body and your mind's way of saying something's not right, something's out of balance, right? Something's being triggered here, something needs some space. So don't ignore those. Acknowledge something about this is hard for yourself. Give yourself time and space to process. Even if it's just a 15-minute step back, I'm going to go outside and take a walk. I'm going to go outside and sit in my car for a little bit. Take some moments back and try to give yourself some space to process what might be happening. Acknowledge something about this is hard for yourself, or something about this is bringing up some difficult emotions. And then if you are able to ask for help, whether it's a coworker, a colleague, a boss, JLAP, somebody. Debrief with a colleague or a good friend, ask to process responses with a JLAP therapist or other mental health professionals. If you continue to have difficulty, consider referring the case out if you can. Ask to be transferred or ask for additional assistance. There are no martyr awards at the end of a trial or a case for people who suffered or put up with the most. You don't get an award for burning out your mental health at the end of something. So if you're seeking longevity in your career, which most of us are, you're going to have to take these timeouts along the way to process and possibly reframe some of what you're dealing with on a day-to-day basis. It doesn't make you any less of a great professional. It just makes you human. And these traumatic events and traumatic cases and people and experiences accumulate over time. We have to figure out a way to offset some of those things. So if we move beyond trauma-informed care to trauma-responsive care, that's the next level. Those are organizations that build and create systems that most benefit the users. The users of the legal system and the criminal justice system are overwhelmingly people that have experienced adversity and trauma. Those systems are not built for those people. Those systems re-traumatize those people. And so if we ever could get to a place where we have trauma responsive care, that looks like us building these systems or helping build those systems that actually respond effectively to the traumatized people that we serve. Okay, so finally, if you notice that you're feeling compassion fatigue and you notice that you're feeling burned out, what are we going to do? There's things that you're going to need to do even before you notice that you've got compassion fatigue. It's like it's not too late if you notice you have compassion fatigue, but it's almost delayed point for an intervention, right? So in order to avoid having compassion fatigue, we need to do these things because we work in helping professions. We need to constantly and continually connect back to our why. Why did we pick this career? Why were we drawn to these professions? What brought us here? What brought us to these places of wanting to be in these careers where we are giving to others and emotionally being there and helping others deal with some of their most difficult problems. And so you probably have a pretty good why. It could be a personal why. You experienced something on a personal level or a family level that brought you to this place or this career, but trying to connect back to that why you're here. Remind yourself that you are human. You are one person and you have a limited capacity. You cannot do it all. You're not going to be able to, and that's okay. That is okay. Just remind yourself that you have a limited capacity. Each day I come to work and I do all the things that I can do, and then that's all I can do. And then I come back tomorrow and I try to do all the things that I can do, and then that's it, and I go home. So reminding yourself that you can only do what you can do. This one was a big one for me, and I've had to come to this in the last few years. Accept that the job has changed you in ways that you didn't expect and could not foresee. I know working in mental health, we know what child abuse is, right? We've heard child abuse, we knew what it is. You don't know child abuse until you're hearing a severely abused 7 or 8-year-old child tell you in explicit detail what a grown man adult has done to their body. Like, we all know what child abuse is, but until you hear those explicit details coming out of a little child's mouth, you don't know what child abuse is. You have general ideas. So these kinds of experiences where you've lost innocence, where you've lost other things that you thought were true, these things change us. So we have to sort of accept that there's pieces of these careers and these jobs that have shown us darkness, that have shown us light, that have shown us resilience, but that they've affected us, they've changed us. And that's okay, right? We wouldn't be human if we didn't hear these stories and hear these experiences from our clients and families, and they not change us. So accepting that the job has changed you in ways that you really didn't or could not foresee. Acceptance is big here. So we also need to accept, like I said, that you have limited capacity in what you can and cannot do. So we often want other people to accept that about ourselves, but we often will push ourselves. So we have to accept that we have limits. And we have to accept that there's some things, especially in large systems, whether it's the legal system, whether it's mental health systems, that there's pieces of those things that are not in our control, and they can be very frustrating, disappointing, disheartening, but that we have to accept that there's pieces that we can't control and that we can only do what is within our control. So having some acceptance around what we can and cannot do. One very important way combating compassion fatigue is connecting with other people outside of work, whether you go play tennis, play dominoes, pickleball, go jam music with friends on the weekends. There has to be a life outside of the job and people outside of work for you. You have to have some kind of hobby, social connections, pets, curiosities. I don't care if you have a rose collection or you do your genealogy from birth till last night. Have some kind of interest or hobby outside of your job. There's been a long-term Harvard study that follows people and looks at income and happiness. It tops out at a certain level. You're not going to make more money and be more happy. It tops out, I'm forgetting the number right now, but I think it's around $110,000, $120,000. Like, you're not going to make more than that and get happier for most people. Happiness tends to go down for a lot of people. So instead of thinking that you need more work to establish this happiness level with money or something, consider that happiness and money may not be connected in the ways that you first thought. And are there other judgments or other ways to judge happiness in some ways? Time with family or time traveling in certain ways. Another way to combat compassion fatigue is having rituals and consistency, whether it's making your bed every morning, doing 30 minutes of yoga when you first get home in the evening. It's having rituals to kind of go about with your day. It's those things that help us to kind of know what to expect in life. We have consistency equals safety is something we tell our PTSD vets. When we have consistency and we know what to expect, they often feel a great sense of safety around that. And so rituals and consistency can bring about inner peace within us.
Lisa, I'm so sorry to interrupt. We're getting right up on time and I'm hoping.
Okay, I'm almost finished. Can I just do 2 more of these and I'm done? Or do I just need to quit, Jordan?
I think we have like 1 more minute that we can.
Okay, so make a clear distinction between home and work. Remind yourself this is the most important. You're responsible to your clients, not for them. You're responsible to give them good legal advice, good care, but you're not responsible for the choices they make. Thank you all so much. I'm sorry to keep going.
No, you're totally fine. If anyone needs to take a break at this point, we'll start a 5-minute break. And Lisa, if you have just a couple minutes, we'll try to answer some of these questions that came in while folks are on a break.
Sure, thank you. I'm sorry to keep going, Jordan.
No, I was enjoying it. And I hope everybody else was too. One of the questions I think goes back to ACEs, and that's why is maternal depression a factor as opposed to paternal depression?
Well, I mean, obviously the mother is the one carrying the babies. The first thought that comes to my mind, right? And if she's going to be probably the one that could be more affected and share those hormones or share those experiences with the child she's carrying. But I would like to look at that genetic factor, right? To see if there is a genetic factor in paternal depression and ongoing mood issues with children down the road. There's probably some research on that, but I'm not super familiar with that right off the bat.
And I'll summarize the next one. Someone had a family that had 3 generations of welfare into adulthood. 4th, how is this systemic and repeated behavior affecting situations being described here? And they also mentioned domestic violence, poverty, fatherhood issues.
Boy, it's so interrelated and it's very complicated. It's complex, right? It's very, very complicated. And it is intergenerational. When you see those role models in families, when you see the neighborhood models, when you see environments and communities where it's accepted that women are devalued or that people are devalued or children are devalued, it's very complicated, ingrained, and multi-generational. It's not something that's easily, quickly fixed.
And then one more, this person is working remotely. What do you suggest when a client, after receiving bad news, says over the phone that they are suicidal?
Wow, that's a tough one, especially over the phone, right? I would try to talk to them as much as possible. See if they would be willing to connect with another person. If you have an emergency contact and you're honestly very concerned about them, maybe you could contact their mother, brother, sister, cousin. I would say at the last resort, contact police only if you think their life is actually in grave danger. Often people say this because they don't have another way to cope. It doesn't mean don't take it seriously, but trying to talk to that person, ascertain, are they really saying that because they're in a frustrated place, or do they actually have a plan and they want to die today, right? Is it something that's imminent? Often there's people that just deal with chronic suicidal ideation when they get bad news. Their first default is, well, fuck, I just want to die. I'm sorry, excuse my language. And so their default is that. And so trying to ascertain, right, are they just in that place or do they actually have a plan? I'm going to go drive my car off a cliff tonight. And that's something that you're going to have to ask for intervention. You're going to have to contact the police about probably. I think attorneys are mandated reporters, I'm guessing as well.
Well, Lisa, that's all the time we have for questions.
Okay.
Thank you so much for doing
Thank you,
this. I
guys.
learned a lot. I hope everyone else has as well. Bye-bye, Lisa.
Sorry I went over. Thank you.
No, it was well worth it. Thank you so much. All right, and you all should be seeing a poll question. And if our panelists for the last session want to go ahead and unmute their videos, we still have 1 more minute for the break and then we'll get started. All right. It looks like it is 2 o'clock, so we're going to go ahead and get started again. Just a reminder again of housekeeping matters. The CLE form was emailed to you. If you didn't receive the CLE form, then please go to arkansasjustice.org/power. You can get the CLE form there. You can also get the materials for the first 2 presentations today. You'll need to enter the CLE code on your CLE form and return that to Carol King, by the 29th at the latest, late CLE forms will not be accepted. Our last panel today is prisoner civil rights litigation. And listen for the CLE code again during this presentation. I'm happy to introduce our panelists today. We have U.S. Magistrate Judge Beth Deere. She's from the U.S. District Court for the Eastern District of Arkansas. She was appointed in 2007 and retired earlier this year. And as Judge Marshall mentioned earlier, Judge Deere was critical to making this event happen. So thank you so much, Judge Deere, for helping with this. We have Professor Terrence Cain from the William H. Bowen School of Law, where he teaches civil liberties, conflicts, criminal law, criminal procedure. And Professor Cain, I had to cut it off there because it looks like you do a lot of teaching. So there were several more courses listed. Jamie Goss Dempsey is from the U.S. Attorney's Office for the Eastern District of Arkansas. She defends federal agencies and employees in civil litigation. She also prosecuted criminal cases and worked on affirmative litigation. And last but not least, we have Greg Jones. He's a partner at Wright, Lindsey, and Jennings. He's got 38 years of trial experience. Greg, this wasn't included in your bio, but I want to make sure Greg gets recognition for being an amazing pro bono volunteer. During the pandemic, Greg made sure that lots of healthcare workers who were putting their lives on the line had planning documents prepared for them at no cost to them. So we really appreciate that pro bono work that you've done, Greg. And now I'm going to turn it over to Judge Deere, who will be moderating this panel.
All right, thank you, Jordan. We do have I think a really strong panel for you here this afternoon. Jordan has introduced everybody. I chose the panel members, and after you hear each of them speak, I think you'll see why. I'll echo the kudos to Greg Jones. He has been such a hero in helping with prisoner civil rights litigation. I have imposed on him so many times that I like to think I now have an easement on his time, and he's kind of my go-to person when I get into a jam and need a lawyer to represent an indigent prisoner. So the panel is going to visit with you this afternoon about prisoner civil rights litigation. And if you are a member of the federal bar in the Eastern District of Arkansas anyway, I'm not positive about the Western District, you are subject to being appointed to represent a prisoner. So we hope we can give you some helpful hints, sort of demystify, ease your mind a little bit if you do get appointed. And if you manage not to get appointed, then we hope this will be a fairly painless 3 hour CLE for you. Now, my part of the program, I'm going to give you just a really quick and dirty evolution of civil rights through the years. So as you'll remember, the Bill of Rights was ratified after the Constitution was, but the Bill of Rights only pertains to the federal government. It only places limits on the federal government's, protects you from interference with your rights from the federal government. It doesn't apply to state actors at all. So if we then fast forward the Bill of Rights to the Civil War, after the Civil War, the states ratified the 14th Amendment in 1868. So the 14th Amendment grants citizenship to all persons born or naturalized in the United States, and it forbids any state from denying any person life, liberty, or property. So it sort of echoes the Fifth Amendment there, and also guarantees equal rights under the laws. Now, over the years, in the 100 years after the Constitution was ratified and the 14th Amendment was ratified, the Supreme Court has one by one adopted many portions of the Bill of Rights into the 14th Amendment, but not all. For example, there's no right to a grand jury in state court, even though that's in the Bill of Rights. So the 14th Amendment is passed, then in 1871, Congress passed the Ku Klux Klan Act. And Section 1 of the Ku Klux Klan Act is what we now refer to as Section 1983. Section 1983, just by in the text, forbids depriving any person of rights and privileges, and it grants a civil remedy for those violations. The only thing is that nothing much happened with 1983 until 1961. And there was a Supreme Court case, Monroe v. Pate, that sort of opened the door to civil rights litigation in federal courts. In that case, the Supreme Court held that Congress had intended to make federal courts the forum or a forum to protect rights of citizens from state actors, because the states couldn't be trusted to do that because of, quote, prejudice, passion, neglect, and intolerance. So that was 1961. Important to know that 1983, Section 1983, does not confer any substantive rights at all. It is merely the vehicle to vindicate rights that you find elsewhere, either in the Constitution or in some federal statutes. Any person can sue under 1983. You do not have to be a citizen, and any state actor can be sued, and that includes municipalities can be sued for money damages, injunctive, declaratory relief. The state and its agencies cannot be sued for money, but can be sued for injunctive relief. In addition, private entities can be sued in some limited circumstances, and that is when they are the contractors basically performing a state function. For example, providing medical care in a prison. In other words, the prison is responsible for providing medical care. So medical providers, even their private entities, can be sued. In 1971, Supreme Court decided Bivens versus 6 unnamed FBI agents. So starting in 1971, Bivens cases applied to federal employees who violated rights. And the law of Bivens in 1983 pretty much tracked. And the courts often would cite 1983 cases, even in cases brought under Bivens. The next significant development was in 1976 when Congress passed 42 U.S.C. 1988. That one was very important to lawyers because it authorized federal courts to award attorney's fees to claimants who prevailed in their claims. So that pretty much gave a shot in the arm to civil rights litigation in federal court. And up to this point, prisoner civil rights cases tracked every other kind of civil rights case until 1996. And in 1996, Congress passed the Prison Litigation Reform Act, or PLRA. It was passed as a part of a Budget Reconciliation Act, which is, I don't have any idea what that is. I see it in the news now, so I know it's some strange way of passing legislation. There was some objection to doing it because, in fact, then Senator Biden objected to tucking it into the budget reconciliation bill because he thought it needed to go through regular order and get some comment and so that it could be carefully drafted. But he was not successful, and President Clinton signed it into law in 1996. And I will have to say, it is not very well written. It's hard to read. It is ambiguous in a lot of places, and it has led to lots of litigation since then. But essentially what the PLRA did was to establish special rules for prisoners. So the rules for other 1983 claimants are completely different in a number of respects. And I'm not going to go through all of them because the PLRA is long and involved, but I'll focus on three. First, it requires prisoners to exhaust administrative remedies. And what that means is they have to go through the jail or prison's grievance process fully before they can file in federal court. If they don't, courts are obligated to dismiss that claim without prejudice. There are a few exceptions to the exhaustion requirement, not very many. Now, I bring this up because if the PLRA also requires judges, federal judges, to screen claims before they can proceed. Before we even order service of process, we're required to screen claims and weed out any claim that fails to state a federal claim for relief or that sues someone who's immune from suit, or if the claim is just frivolous. So if you're appointed to represent a prisoner, you can assume that a judge has reviewed the complaint and that we have already weeded out claims that have no legs. And we don't appoint lawyers in every case, even those that proceed and that we order service of process for. We don't automatically appoint counsel. Many of these cases go out on summary judgment. Again, if you're dealing with almost every one of them is a pro se complaint, meaning that the prisoner has written it himself or herself, and clearly they're not written by lawyers and they're not well drafted. We read those liberally, and if they present a colorable claim, we do go ahead and order service. But again, we don't appoint you just because we have ordered service of process. So another special rule for prisoners is it requires a physical injury to recover damages for emotional or emotional distress. So without a physical injury, there can be no recovery for those emotional damages. Other regular non-prisoner cases, those damages are available. And then the third one I'll emphasize is the Prison Litigation Reform Act has a whole section limiting attorney's fees. And again, this is one of the most poorly written sections in the PLRA. And I'm not even going to read it to you because, or I'll read just a portion of it and you can see if this makes any sense to you. The statute says when a monetary judgment is rendered or is awarded, a portion of the judgment not to exceed 25% shall be applied to satisfy the amount of attorney's fees awarded against defendant. If the award of attorney's fees is not greater than 150% of the judgment, the excess shall be paid by the defendant. There's got to be a better way to say whatever it was they were trying to say there. But what it has, we get to, now we've got the Prison Litigation Reform Act, and then we have some judge-made law that follows. Well, in 1998, there's a case out of the Second Circuit, and that court held in Blissett v. Casey that it appears to provide that plaintiffs' fee recovery might now be capped at 150% of the damage award. I'm not sure how the court got that from the statute, but that's what it says. Now, in fairness to the Blissett court, the court said, you know, this is maybe a problem, 150%. That's not always going to be possible to give somebody justice. Nobody's going to want to represent prisoners if that's there. But since then, federal courts have uniformly adopted this view. And so now the rule is all over the country, the attorney's fees in a prisoner case. Now, regular civil rights case, you still have a lodestar, you keep up with your hours, you get a lodestar. But for prisoner cases, the monetary award, the attorney's fees are capped at 150% of the monetary award. Now, I'm not talking about injunctive relief right now, but if you're only suing for money damages, then the fees are capped at 150%. I say they're capped, that's all the defendant is going to be responsible for. So, and Professor Cain is going to talk to us a little bit about he's on the jury instruction committee for the 8th Circuit, Model Instruction Committee. And so he's going to talk to you a little bit about the jury instructions and the law that supports those. And that is that if you are successful in a case where the issue is procedural due process, you didn't get a fair disciplinary hearing because the hearing officer was the same as the one who wrote the disciplinary, you only get nominal damages. Nominal damages are $1. So any case that the prisoner plaintiff prevails on where $1 is awarded, the attorney's fees are capped at $1.50. So, for that reason, prisoner 1983 cases belong in the category of cases where we need volunteers, and they end up being pro bono cases because of that interpretation of the Prison Litigation Reform Act. So then on top of that, we have a judge-made special rule of qualified immunity. And I know Professor Cain wants to talk a little bit about that. Then Jamie Dempsey is going to talk to us a little bit about the federal perspective. Now, earlier I said the law of Bivens, 1983, were the same. You could cite one case, law in one case for the other until you couldn't. So now the Supreme Court has made Bivens cases in a completely separate category. So I'm anxious to hear Jamie's take on that, and particularly to talk to us a little bit about the Hernandez case. So that's my quick overview of how we got to where we are. And I hope that's demystified it a little bit. The biggest concern I hear from lawyers when we ask them to take one of these cases is, I can't do that, I don't know anything about 1983. Well, you really do, because it's basically constitutional law, but with this overlay of the PLRA. We have a whole staff of pro se law clerks who do nothing but work on these cases, and they are a wealth of information, and they're happy to help you if you get appointed on one of these, answer your questions. We're very grateful when you volunteer. And then I'll put in one other plug for Arkansas Access. They not only have done a great job on this program, but I'll tell you, if you do volunteer in case, a state case, that satisfies your pro bono requirement as far as the federal courts are concerned. And if we ask you to take a prisoner case, if you can show us where you have taken another pro bono case, then you can avoid the 1983 case if you really don't want to work on it. Okay, I've tried to make that quick. So now I'm going to turn it over to Professor Cain, and I'll let you jump in to whatever part of that you'd like.
Well, thank you, Judge Deere. I'll start with the jury instructions. The 8th Circuit website has a link that'll take you to both civil and criminal jury instructions. And the civil instructions are impressively comprehensive. And I felt that way even before I had any role in trying to revise the section I was charged with revising. And what I would recommend to any lawyer, either drafting a complaint or preparing to defend a case, to take a look at the jury instructions and formulating your theory of the case as a plaintiff and anticipating what you might have to defend as a defendant. Because the jury instructions not only contain what the finder of fact will have to walk through in deciding who will prevail and who won't, but there's footnotes and there's commentary for each instruction, so that you'll see the case law that provides the support for the instruction. And that's a good jumping off point for research. So if you say, I know very little about Section 1983 and I need a primer, and I'd rather not read a law review article that's several hundred pages and even more footnotes, then the jury instruction would be a good starting point for you to read those cases and then expand your research from there. And I think that's the case in any case that might go to trial, that the jury instructions is always a good place to start and refer to throughout the litigation as you develop your theory of the case and you develop your defenses. Now I want to turn to the topic of qualified immunity, which during the past year or so has gotten quite a bit of attention in the popular press, not exclusively, but significantly because of the killing of George Floyd and the criminal trial afterwards, and some other fairly high-profile incidents involving law enforcement officers and a person. Qualified immunity attaches to any state actor, not just police. If you are, and by state actor, I mean a governmental actor, a non-federal governmental actor, and a governmental actor at the subdivision level of a state. So county, anything below state capital S, those are persons who are subject to being defendants in Section 1983 cases. But I want to step back a second. Judge Deere mentioned the Ku Klux Klan Act of 1871. On April 20, 1871, Section 1983 became effective. That became the law. And the text of Section 1983 doesn't mention anything about defenses. It doesn't mention anything about immunities. The defenses and immunities that exist today are all judicially crafted doctrines. Qualified immunity began its, I would say its birth, if you will, was in a 1967 case in Pearson versus Wright, where the court held that there's a good faith defense to a claim pressed through Section 1983. That is, if a person says that a county official or city official violated his or her federally protected right, if that defendant could then assert that he or she acted in a good faith belief that what he or she did was lawful, Pearson versus Wright recognized that. Now I want to drop sort of a metaphorical footnote here. Qualified immunity arises in cases where the government official is sued in his or her individual capacity. A Section 1983 defendant can be named in his official capacity or his individual capacity. The difference being official capacity claims are against the governmental entity itself, not against the person who acted for the governmental entity. And with official capacity claims, there is no qualified immunity that applies. Instead, if there's an official capacity claim, the plaintiff has to prove that there's an official custom or policy of the governmental entity itself that essentially instructs its actors to go out and violate people's federally protected rights. You won't see very many official capacity claims in Section 1983 cases, because proving to a court that, and even before you even before you get to trial, that it is official policy or custom of the municipality that its officers go out and commit excessive force. Okay, good luck trying to find a municipality in these United States that at least explicitly has that a policy, as a policy. Now, there is a theory whereby if you can establish a pattern and practice of violations of people's federally protected rights and the municipality looks the other way, that can constitute an official custom or policy, but trying to discover that kind of information early in the litigation is onerous, to say the least. Therefore, that leaves individual capacity claims, but individual capacity claims give rise to the applicability in cases of qualified immunity. Now, in the Pearson case, the Supreme Court said there's a good faith defense, but if a person asserts that he or she acted in good faith, then discovery is necessary to put that to the test. If you're the plaintiff and the defendant says I acted in good faith, then you get to do some discovery to put that to the test to see if that person is genuine in the assertion of good faith. And that the Supreme Court found that unworkable. And so 14 years later, 14 years after Pearson versus Wright, the court decided Harlow versus Fitzgerald and replaced the subjective good faith defense with the objective reasonableness defense. Because the court's view was, if you are a state actor and you're engaged in discretionary decision-making and you make a mistake, that mistake should not result in your being saddled with the prospect of civil liability or having to go through civil litigation. And so as early as a court can, it should determine whether a case against a state actor should proceed so the state actor can go back to his or her duties and not be bogged down in litigation. So Harlow held that instead of, forget about the subjective good faith. In fact, that doesn't matter anymore. What matters is when the government official, the defendant, did what he or she is alleged to have done, was there pre-existing law under identical or nearly identical facts as exist in the litigation that said, you can't do this. In other words, a way I like to put it is, qualified immunity establishes a presumption that unless some case law on nearly identical facts or identical facts tells you ahead of time, you cannot do this, the presumption is you can. Not that you should do it, but you can do it and not be subject to civil liability if you do. And in fact, you can keep doing it until such time as a court in a case on identical or nearly identical facts says you can't. And that's where the controversy surrounding qualified immunity comes to the fore, because you'll have cases that might have might have facts that are fairly conscious shocking, and you wonder, how can the government or the individual acting for the government get away with that? And and the answer in many, though not all cases, is, was there pre-existing law in a case on identical or nearly identical facts where a court had already declared that off limits? So, for example, there's an infamous qualified immunity case where law enforcement officers were conducting a search warrant, and one of the officers in the course of conducting the search warrant stole the subject of the search warrant's money out of his house. Now, you would think you can't do that, and you would be right in a moral sense. But the question in qualified immunity is there an existing case that was nearly similar where law enforcement officers executed a search warrant and in the course of executing a search warrant stole some property from the subject of the search warrant? And if you don't have that case, then according to a present doctrine, the law wasn't clearly established that conduct is off limits. Therefore, an officer can engage in that conduct and not be civilly liable. Now, that doesn't insulate or immunize the officer from other discipline within the department or losing his or her job or being subject to scorn and public criticism and the like. But Section 1983 says to that person, you won't be civilly liable or subject to civil litigation. Now, in determining what the law is for the purposes of Section 1983, there's a case called Pearson versus Callahan that gave district trial court judges like Judge Deere a choice. when you're asked to determine whether the law is, when you faced with a Section 1983 case and qualified immunity is raised as a defense, you got two things you can do. First, you can say in this particular case, this conduct violates federal law. You can make that finding that on these facts, I, as the trial judge, think this violates federally protected, violates a person's federally protected right. But the inquiry doesn't end there. Then you have to ask, even though I make this finding that this violates federal law, has there been a finding before I make the finding that this conduct violates federal law? In other words, what does the authority look like, or what did it look like on the date the defendant engaged in the conduct that led to the lawsuit? So if your case is the very first one where anybody has said this violates federal law, then the defendant has, the case against the defendant has to be dismissed, because clearly established law is sort of backward looking. Was the law clearly established on the date the defendant acted, rather than from this point forward, I'm declaring this as the law, and the next time it happens, the law will be clearly established and the next defendant won't get the benefit of it. Now, I don't know if it's an oddity, it might be a bit of an anomaly. The first case, and this may raise some controversy among the panel and the participants, the first case, you say, well, how do you establish the law? There always has to be a first case. Well, the first case is always doomed to lose, because if by definition, if it's the first case, the law isn't established and the defendant gets the benefit of the absence of clearly established law. However, that first case can establish the law going forward. But the twist with Pearson versus Callahan is a court can bypass, if it chooses, the declaration or the finding that particular conduct is unlawful and just ask the question, let's accept these facts as true as alleged by the plaintiff. Let me do some research to see if there's a case on the same facts or nearly the same facts. If there is, then qualified immunity won't apply. If there's not, qualified immunity will, and then you can just stop. You can stop without ever reaching the question of pre-existing law notwithstanding, this particular conduct is or ought to be unlawful. And then finally, before I pass it on, because I don't want to monopolize the time, in all the United States Circuit Courts except two, in looking for case law that would establish that the conduct of the defendant was declared off limits before the defendant engaged in it, 11 of the 13 circuits said you can look outside the circuit for case law that's on point. And the 8th Circuit is one of those circuits too. The 8th Circuit says not only can you look at other circuit law, you can look at state court cases, you can even look at district court cases. The 8th Circuit takes a very broad view in where it will look for cases that are on point to determine whether the defendant, whether the law was clearly established. The 11th Circuit takes a pretty almost dogmatic position. Only 11th Circuit cases count. So say for instance, in every other circuit, a particular kind of conduct was deemed violative of federal law. And all those circuits, the law will be clearly established. But let's say that the 11th Circuit hadn't gotten to the issue yet, and therefore there's no 11th Circuit law on it. The 11th Circuit will ignore all that out of circuit law and say that in the 11th Circuit, until such time as this court holds that this conduct violates federal law, the law is not clearly established and the defendant is entitled to qualified immunity. The 2nd Circuit has conflicting cases. There's an earlier 2nd Circuit case that says the 2nd Circuit will look outside the circuit, and there's a later 2nd Circuit case that said it won't. And given that they're both panel decisions and a later panel of a U.S. Circuit Court can't overrule a prior 3-judge panel, it's unclear in the 2nd Circuit whether out of circuit law can count, because given those conflicting circuit court decisions, the 2nd Circuit hadn't taken it up in bank. A party can argue you can look outside of circuit and have authority to point to that, to support that. And another party can say you cannot look outside of the 2nd Circuit and there's authority to support that too. Well, I've drawn on long enough. I hope I didn't go too fast. I hope I wasn't incoherent. And I think it's time for me to turn it over to the Honorable Greg Jones.
Well, that's probably a contradiction in terms, Professor Cain, but I appreciate the thought. Let me start my portion with a question. and I'm going to give you a hint. This has to do with psychological stages, and specifically denial, anger, bargaining, depression, and acceptance. Now, does anyone know what those stages refer to? If you thought or guessed that those are the 5 stages of grief, you would be wrong. You see, those actually pertain to the 5 stages of a Section 1983 prison case appointment, the appointment to you. You see, initially the denial is, no way. How could I get appointed to this? I don't know anything about this. Followed by anger. Dang, I can't believe this. I don't have time for this crap. Can't say that word. Bargaining. Well, maybe if I tell the judge that not this time, but I'll do it later, maybe I can get out of this. And folks, if you fall in that category, I'll urge you to look at local rule 83.7 about withdrawal or substitution. But then there's a 4th stage, and that's depression. Crap, I can't get out of this. Followed by the 5th stage. This is going to be the greatest case of my career. Now, for a moment, let me focus on that 5th stage. As Judge Marshall pointed out earlier today, this process is not simply fulfilling your oath of office or oath that you took when you were sworn in. It's really more than that. And it goes back to something I heard almost 40 years ago from the late Judge George Howard Jr., who told me this when talking about this arena. He said, civil rights are precious. In fact, they're second only to life itself. Judge Howard was right about that. When you take these cases, you are serving as a beacon of light for someone who may have almost no other rights. Think about that. It's a responsibility. And think about this too, when Judge Deere sends you that appointment order, that person, that defendant, or excuse me, that plaintiff, may have no other alternative, and they may have no other rights really to think about while they're sitting in prison. And we can go into other issues about rehabilitation and stuff, but just kind of contemplate that. So if you get an appointment, I urge you to jump over those 4 initial stages and focus on the 5th one. Before I go, let me share with you the one word that you've been waiting for this almost 35 minutes. And that's this. It's the one word that will make you glad that you attended this CLE section. And that word is the code word, enigma. You need that to get credit for this. Okay? I know there was a question about that earlier. So let's get back to our story. I've touched on the civil duty side of these appointments, but there are more. And one key word is experience. Jury trials these days are scarcer than hen's teeth, at least as far as I'm concerned. And if you accept an appointment, don't get out of it, you're almost guaranteed a civil jury trial. And I'll tell you this, these types of cases make for an excellent first jury trial. They're usually fairly narrowed factually, at number one. Number two, they don't take all that long. Usually you can get one done in a day or two. Some other key words about the notion on taking these appointments. War stories. We're lawyers. We love war stories. We especially like war stories that involve who? Us. Now think about this. How impressive is it going to be to your relatives if you tell them, say you're now 70 years old, you're sitting on the front porch with your grandson, and you tell them, once I had this trial involving a breach of contract, or once I had this trial involving the doctrine of worthier title. How impressive is your grandchild going to be with that? Contrast that here. Once I took a man's case It was a constitutional right that had been wrested away from him by two despicable persons who took him in a dark corner and beat him about the head and shoulders with piston-like blows. Who's going to listen to your war story? With these court appointments, you get the latter rather than the former. Now, those of us who also handle contract cases, no offense, but just think about that. The fact patterns are normally incredible, and they're tragic, and any number of things. So from that standpoint, these cases can be fascinating. Let's talk a bit about the practicalities of appointment. Communicating with your client. Promptness is important. Remember this, your client's in jail. There's a good chance they're suspicious of the entire system, including you as the newly appointed attorney. They didn't select you, but daggone Judge Deere is the one who selected you, and Judge Deere already dismissed half of their case. So you have to develop some level of trust with your client. How do you establish that trust? Well, one way is to communicate promptly. I urge you to consider sending a letter promptly upon your appointment. And indeed, as one magistrate judge from the Western District of Arkansas told me just this morning, promptness is key. Let them know about it. Think of it as an engagement letter. Set out what you're going to do for that prisoner, and perhaps most importantly, place limitations. Show that it is a limited engagement to address this case and the remainder of this case, whatever persists in the underlying action. Otherwise, if you don't place those limits on the front end, I've found that some of my clients, when I hadn't done it, consider me not just their lawyer on this case, now I am their general counsel. I'm there to advise them on everything that might come up. So keep that in mind and know that you may have to remind them of that very limited engagement from time to time. Some logistics of communication, logistics of mail. Keep in mind, mail going into the prison is subject to screening. So it's best to, when you communicate, and I'm not exactly sure how fail-safe this is, put on your envelope and on the letter itself something like attorney-client mail or legal mail, attorney-client communications. Talk about logistics of meetings with the client. Normally, your opposing counsel, if you're dealing with the Attorney General's office, usually they're pretty good about helping to facilitate things. Normally, it's the warden's secretary who helps to coordinate the setting up a meeting. You'll need to give them a few days' notice and be cognizant of a prison's schedule. One critical point to keep in mind about scheduling, do not try to set it up at what time? Chow time. Don't do it. It's not going to happen, and your client probably doesn't want to talk to you as much as he wants to get that extra baked potato or whatever. So don't set up at chow time, and they've got kind of odd chow time, so just find that out. Also, don't set it late in the day. If it's late in the day, either your meeting with your client may be abbreviated, or you might not get to leave the prison that night. I doubt that you'll want to do that. I'm kidding about that part. So let's talk about breaking into the prison. All right. We hear a lot about prison breakouts, but how do you get in there? Well, as I say, you can arrange a meeting with the warden secretary usually, but keep this in mind. As you go in, you will be screened. You'll go through a detector. You'll need an ID. You normally can't take your phone. You may have to make, if you're a laptop person, you may have to get special permission to take a laptop inside. And I'm not even sure how often that's granted these days. Talk to your client early on about the confidentiality of the meetings. They tend to gab a bit about their cases, and it's important for you to express to them the importance of the attorney-client privilege and how that can be waived. Make sure you've also reviewed the latest pleadings. And oftentimes, you'll find that there are multiple complaints in the case, amended complaints. So be sure to look at least at the last one to see what exists in the case, not to mention motions that may have been granted that have foreclosed some of those claims. So clarify before you go in there what issues remain. And then when you're meeting with your client, go over expected outcomes. they may have this view that, hey, this is going to be great. I'm going to win all this money. I'm going to, all these things are going to happen. Well, that isn't going to happen. There are, since 2015, Judge Deere's office was kind enough to look at this for me and concluded that since 2015, there have been only 6 verdicts in favor, in a 1983 action, in favor of the litigant, the plaintiff. So that's few and far between. There have been a good number of settlements that have been relatively favorable. So it's not a complete lost cause. And again, you have to think about what sorts of victories are out there. And for example, monetary relief may be part of it. Injunctive relief may be part of it. In one case that I had, I think Judge Deere's familiar with, my client was actually transferred out of the state of Arkansas to another prison system. That was how we worked the deal. So be inventive on this. I know my time is limited because Ms. Dempsey needs to go forward. Let me suggest this. When you get in the case, oftentimes it's at a later stage of development. Check out that scheduling order. See if the time to conduct discovery still is out there. And you may need to file a motion to reopen discovery and just be ready to do that. Normally, the courts are really good about accommodating you if you've got a good basis for it. If you're looking for a go-by on something like this, this is one that one of my associates did recently. It's in case number 118 Civil 25. That was 118 Civil 25. It was document 160. So there's a free form for you if you need. Expenses, and I'm going to try to wrap up here pretty quickly. As I say, chances you won't win the case. If you do, chances of getting attorney's fees are pretty limited, but you can get reimbursed for reasonable costs of conducting the prosecution. And that includes money for depositions. And I urge you to look at local rule 83.6 that deals with expenditures, and know that expenditures in excess of $500 will need advanced approval from the judge. And Judge Deere, I've thought about this, inflation being what it is, maybe you guys need to think about revising that. But anyway, that's another thing. One last thought. I don't have time to go into trial tactics, although those are some of the more interesting aspects of this process here. But remember, it is a limited engagement. If you're appointed, the judge will likely, if you want, let you out if there's an appeal. So I will say this, if appellate practice is your game, then you probably can get taken on if you want, or you can get an appointment from the 8th Circuit to argue a case. And I have an associate who just yesterday argued to the 8th Circuit. It was her very first appellate argument, certainly her very first federal argument. She now has experience that she would have gotten probably no other way in her first 2 years of practice. There's more to talk about, but we don't have that time and you don't either. So let me now turn it over to Ms. Dempsey to enlighten you on Bivens.
Thank you, Greg. And so we've mostly been talking about Section 1983 litigation. As Judge Deere mentioned earlier, Bivens has been judicially created. There is no statute that kind of addresses something being done under the color of federal law for federal employees. So Bivens was a case, it was a warrantless search and arrest, and so a Fourth Amendment alleged violation. And then on down the line, how it got extended to prison was later in 1980 in Carlson versus Green with that's a claim about an Eighth Amendment violation. So cruel and unusual punishment in terms of medical care and deficiencies in medical care. And the standard, and that's going to be the vast majority of the cases that arise either under Bivens or 1983, a claim that a federal actor has been deliberately indifferent to an inmate's serious medical needs. And I'm sure we can all imagine all of the different facts that come up to flesh those issues out. The other type of claim that'll arise, or other generally type of claims that arise in the prison context, are Eighth Amendment claims about either excessive force by a staff person or a failure to protect an inmate from excessive force. And again, that's a very fact-intensive deal. So unless someone like me or someone at the Attorney General's office is able to defend on undisputed facts about what happened, a lot of those will end up going to trial because of just the very factual nature of those failure to protect and force cases. But anyway, so Bivens kind of has rocked along. There are these Eighth Amendment claims. There is not under Bivens a First Amendment retaliation claim. The Supreme Court has never recognized that for federal prisoners. And oddly, you know, as Bivens is now being more and more limited in recent years, oddly enough, the Eighth Circuit looked at this First Amendment retaliation issue recently in Gonzalez versus Bent. And while it observed that there is no First Amendment claim, it went on to analyze the merits of the First Amendment claim and decide that the inmate failed to state a claim. So I'm a little curious as to where the Eighth Circuit is going with that, but that's neither here nor there. So over the years, specifically in Ziegler versus Abbasi in 2017, the Supreme Court noted, you know, we've been addressing this issue of the Bivens remedy for many years now, and Congress has never acted to create this remedy. And we're not going to continue to extend this implied remedy. So when these new contexts come up, we're going to take a hard look and say, you know, is this a new context? And if so, should it be extended? And they keep saying no. and it's getting to the point where the facts are getting real specific. So for example, a recent Eighth Circuit case, Ahmed versus Waker, involved some individuals who were arrested based on a federal agent's falsifying some information. And in that case, the Eighth Circuit said, this isn't enough like Bivens, and there's not going to be a Bivens remedy here. And so to me, you can't just say, this is a Fourth Amendment violation, so we get something. You really have to dig into these facts, and it'll be interesting to see kind of where the case law and precedents go on that. And as Judge Deere mentioned, of course, in the federal prison, the inmates do also have to exhaust their remedies in order to pursue a Bivens claim. And that's a pretty involved process. It's a 3-step process in the Bureau of Prisons. It can take months. You know, they have to wait for a response. They have to appeal it. And so another thing that is available to inmates that we've seen in the federal system is that they could file an administrative remedy for a tort claim under the Federal Tort Claims Act. So if you're wanting to claim medical negligence, for example, instead of a deliberate indifference, you would simply send your claim to the agency. If it's denied in 6 months, you can go ahead and file your lawsuit. And so there's an interesting interplay between those. And I will note, because his name has come into the news lately, Oscar Stilley, who has filed one of the first lawsuits against the Texas doctor, was incarcerated at the Forest City Prison. And he figured this out and filed his own claims, as well as, I would say, prepared hundreds of documents for other inmates to pursue these Federal Tort Claim Act cases.
Jamie, let me interrupt you. We have a question on the Federal Tort Claims Act. We have a question. Can you pursue a remedy, a state remedy under the Federal Tort Claims Act?
I'm not sure I understand what you mean, what the question means.
I think the question is, can you use the FTCA to apply state civil rights law?
No. So Federal Tort Claims Act is really, it's a lawsuit against the United States based on that state's tort law. So this would be applying Arkansas law and claiming that someone at the prison, was negligent in, whether it's a slip and fall or a medical malpractice or.
Right, but then, so why couldn't you use the Arkansas Civil Rights statute, use the Federal Tort Claims Act to pursue a claim under the Arkansas Civil Rights Act?
You know, I mean, I guess it would be a private right of action under state law. But I don't know. I have not seen that happen.
That was a very good question.
It's a very good question. I would think that there would be a problem in terms of it, because the Arkansas Civil Rights would mirror. I mean, because I'm not familiar with it. I don't know if that specifically says someone acting under state law and not federal law. So then you get into, I don't know.
And is a violation of the Arkansas Civil Rights Act a tort in terms of a characterization matter? Because the Federal Tort Act is what is state tort law.
Mm-hmm.
Can one argue that a violation of the Arkansas Civil Rights Act is itself a tort under Arkansas law? And if it's not, then I don't see how that would fit under the Federal Tort Claims Act.
Right.
All right, so we have another question. See if this one, anybody, well, I'll let Jamie, I'll let you get back to yours, but be thinking about this. Can 1983 violations be used as an affirmative defense by a prisoner accused of killing or assaulting a prison guard? I'm going to say the answer to that's going to be a no. I don't think it's a shield. I think it's a sword. I think it's a vehicle to vindicate a right. But I don't think that would be I don't think you can use it.
Is the person saying, so if an inmate kills a guard, can the inmate raise as a defense that the guard was in the course of violating the inmate's federal right? Well, Section 1983 wouldn't be a defense like that, because for one thing, you know, the prisoner wouldn't be a state actor for the purpose of Section 1983. But if it's a homicide case, I mean, you just have the garden variety self-defense that could be raised.
All right. The questioner says I was referring to intentional assaults by guards. I mean, I think you've got a defense there, but I don't think it's going to have anything to do with 1983. All right, Jamie, you can pick up wherever you left off.
I think I've pretty much wrapped it up. Oh, the other thing, like 1983, the remedy under Bivens is against individual defendants and money damages. So.
Right, and in this, I think in this latest, there's a pretty recent Supreme Court case, the Hernandez case, where Justice Thomas wrote a concurring opinion arguing that the Bivens doctrine should be abandoned altogether. So if Justice Thomas prevails, then Jamie will have less work to do.
Just different work.
Well, yes, less of that type of work. All right, if we have any more questions, or Greg, you can pick back up with your helpful hints. Let's see. Yes, the code is Enigma. That's a question we're answering. Same code word, Enigma. Oh, but somebody already answered that. All right. Okay, so Luther, maybe I'm not supposed to, do you care if I say your name, Luther? Has asked, why are appointed lawyers virtually guaranteed a trial? Good question. Greg?
I think it largely goes, Luther, because of the screening process. There is a screening process at the front end. Normally by the time, not always, but by the time it comes into the appointed attorney's lap, there's already been a summary judgment motion filed and denied. Not all the time, but most of the time. So we're at a fairly advanced stage in the case, at least from the standpoint of kicking the case out. So now you're heading down the road. You know, you could get derailed. That's true, but there's a really good chance that the preliminary matters have been kind of kicked out. So there you are.
Right. As a practical matter, I can tell you, we only appoint lawyers in cases that we feel like they're going to go to trial. Sometimes they don't, but as Greg said, we normally make the prisoner get through summary judgment before we appoint a lawyer, which makes it a little bit hard for the lawyer because you get in late on the case. Okay, I see Jordan back on screen. Are we out of time? Oh, we are out of time.
And we're at time. Thank you all so much for being here today. We had a wealth of knowledge on this panel. We appreciate you all sharing. Thank you for everyone who took 3 hours out of a Friday to attend today's event. We're really glad that you did. Just a few reminders as you're leaving. The CLE form and materials are available at arkansasjustice.org/power, and that's in the chat as well. One more time, arkansasjustice.org/power. Please return your CLE forms by the 29th to Carol King. Her email address is on the CLE form. She will not accept late CLE forms, so please make sure to get them in on time. And that's all I've got. You'll get a survey when you close out the webinar. Thank you all so much for being here today.
We have one more question.
Yep.
Can we just answer it
If
off?
folks have satisfied their CLE requirement now, but if
Okay.
they just want to learn, they can stick around and we will answer as many questions as you all feel like answering.
All right, so I think this one's probably for me. How often does administrative exhaustion under the PLRA come up as an issue? It comes up a lot. Well, for one thing, there is no federal exhaustion. It's jail by jail, prison by prison. You know, it's written out for the inmates, but again, there are time limits on it depending on which jail you're in. So they oftentimes miss the cutoff for filing a grievance or for appealing it. And again, there are very few exceptions to exhaustion. Sometimes if they've been put in segregation and they weren't able to, you know, get the appeal file, sometimes I'll give them a little grace there, but otherwise, you're pretty much dead in the water if you didn't fully appeal your grievances. Do federal employees get appointed to these cases when it could violate Title V? Well, you know, we have a 13th Amendment too that passed after the Civil War about involuntary servitude, but we sort of breezed past that one, and I'm guessing we sort of breezed past Title V too. But again, we do take volunteers, and CJA lawyers, the criminal defense bar that we appoint in criminal cases, normally are willing to take some of these, even though it's not the same thing. What is the statute of limitations 1983 claim? Another good question. And how does exhaustion impact that? Very good question. 1983, the Supreme Court held back in the 80s, I don't remember the case. You go by the state general tort statute of limitations. So it's going to be different state to state. In Arkansas, it's going to be 3 years. How does exhaustion impact that? I think I just read, but I don't know for sure. I think it's told during the time that a grievance is being, but the problem is that's never going to come up because, for example, in the ADC, the time limits on filing, I think to file a grievance is 15 days, and then you have to file an appeal. It would never be 3 years and you still haven't exhausted. You would have already missed the deadlines.
All right, last call for questions. You've got an expert panel here. If you have any questions, looks like we still have 86 people. So if you have any questions, now is your chance to ask them.
Or anything else you want to ask Greg about practice law, or Professor Cain about teaching, or Jamie about the U.S. Attorney's Office. We'll answer anything you want to know. All right, I think we're done.
All right.
Thanks again. Listen, Jordan and Christy have been absolutely fabulous. I know the whole audience is not here to hear me say that, but I mean, they are fabulous. They do a fabulous job. And then again, I've imposed on my friends to serve on this panel, and thank you again. Appreciate it.
Thank you all.
Thank you.
Are we excused, Judge?
Yes, you are relieved until your next appointment.
And I hope I didn't monopolize the time.
No, it's a big subject, and that's the hot topic. Qualified immunity is the hot topic.
All right, thanks all.